Okay, great. We are now live. Senator Kelly, Chair Kelly, good to see you. Well, welcome everyone. Good afternoon to the Judicial Proceedings Committee. Today's Wednesday, February 3rd, 2021. We have 10 bills on the docket today, and I'll go in order, and then we'll start off with the chairwoman here. So first, we'll start off with Senate Bill 202. Then we'll move on to Senate Bill 254. Next is Senate Bill 63. We'll then go to 140. We'll then go to Senate Bill 23, Senate Bill 78, Senate Bill 229, Senate Bill 263, and we'll wrap up with two of my bills, Senate Bill 599 and Senate Bill 601. So with that, Chair Kelly, you are up with Senate Bill 202. The floor is yours.
Thank you, Mr. Chairman and members. The main purpose of Senate Bill 202 is to eliminate unwarranted disparity and the lack of transparency in Maryland's response to petitions for parole consideration for parole-eligible lifers. In addition, Senate Bill 202 also increases the time that such an inmate must serve from 15 to 20 years before gaining eligibility for parole consideration. The bill applies to both parole-eligible lifers whose petitions are handled by the Maryland Parole Commission, as well as those whose petitions are handled by the Patuxent Board of Review. And it takes the governor out of the approval process. Maryland is one of only 3 states in which an inmate serving a parole-eligible life sentence and recommended for parole by the Parole Commission can be denied parole unless the governor approves. The only other such states are California and Wyoming. Parole-eligible lifers, after decades of incarceration, tend to have health challenges and age-related disabilities, which pose significant costs to Maryland taxpayers. And at a time in the life cycle when many such inmates have very little probability of eroding public safety. Under the current Maryland statutory scheme, any parole petition from a parole-eligible inmate requires affirmative action on the part of the governor within 180 days following a unanimous recommendation by 2 parole commissioners. While some previous administrations denied parole to all parole-eligible lifers, the Maryland Parole Commission has gotten around that to some extent by quietly recommending in some cases that governors commute these inmates' life sentences to a specific term of years so that the Parole Commission then can later parole the formerly life-eligible inmate from the number of years to which the original life term was granted, and now that the original life term has been quietly commuted by a governor. This 2-step strategy lacks prior notice or any required public documentation after the fact. Without sunshine or transparency, governors have little concern regarding the need for victim notification or for disapproval by the general public. The behind-the-scenes use of commendation also shields governors from public awareness or displeasure about hidden demographic disparity. And there's a lot of disparity. If we were to really look at the cases that have come to light, many of those who got the quiet commutation and then later were released from the number of years to which they were subsequently resentenced in a way by the governor were people who were not minorities or not members of groups that experienced systemic disparity. 2 recent governors, Glendening and Ehrlich, during their terms of office, supported the current flawed system. You heard their public cries of life means life. But both have since announced their strong regret and are on public record as supporting reforms such as those represented by Senate Bill 202. Maryland could also use the budgetary savings from releasing certain parole eligible lifers who do have not only a record of reform documented by the Parole Commission, but they have chronic disabilities, extreme old age, or even the need for hospice, while not eroding public safety. Maryland also needs to accomplish such goals with transparency, with public accountability, and without unwarranted disparity. This General Assembly can facilitate justice, fairness, and transparency, can get rid of unmitigated disparity by removing the ability of governors to impact the granting or the withholding of parole for parole eligible lifers who have been expertly vetted and recommended for parole by either of the two applicable Maryland commissions. I therefore ask for your strong support for public accountability, for lack of disparity, for public transparency, and for your support of Senate Bill 202. Thank you.
Excellent. Thank you, Chair Kelly, and thank you for your years-long work on this issue. Look forward to making progress with you this session. Your first witness for the panel is Ms. Meadows, and she is the primary witness, so she'll have 5 minutes. So Ms. Meadows, good to see you, and the floor is yours.
Good afternoon, members of the committee. My name is Lila Meadows, and I'm a clinical faculty member at the University of Maryland School of Law. For many years, I've represented men and women, many of whom were convicted as juveniles in the parole process. I urge you to support Senate Bill 202 and remove the governor from the parole process. I want to take a moment to talk about how exhaustively lifers are vetted by the Maryland Parole Commission, which Senator Kelly alluded to. Currently, an individual serving a life sentence becomes eligible for parole after 15 years. Senate Bill 202 would increase that to 20. At the point of eligibility, a candidate for parole has a parole hearing in front of 2 commissioners who will consider factors like the circumstance of the crime, input from victims, evidence of rehabilitation, as well as a client's home plan. Those 2 commissioners have 3 options. They can refuse parole entirely. They can forego a decision that day and instead schedule a rehearing for any number of years in the future, which is a very common outcome, particularly for the first time people go up for parole. Or for candidates who they feel meet the statutory criteria, they can schedule a psychological risk assessment. Risk assessments are conducted by DOC clinicians and can take anywhere from 12 to 36 months to schedule, in my experience. Following a risk assessment, the original 2 commissioners who heard the case will receive that report and they review it and they make a decision about whether or not to set the client in for a rehearing for some point in the future, or whether to move them forward to the next step of the process. That next step would be what we call en banc consideration, where the entire parole commission meets in a closed door meeting and considers that client's case and whether or not they're suitable for parole. The commission takes a vote, and you need a majority vote of the 10 commissioners in order to receive a recommendation to the governor. This is an exhaustive vetting, and all told, it can take anywhere from 2 to 3 years to move through this evaluation process. When a case is recommended to the governor, it really enters what's akin to a black box. Clients, and if they're lucky to have an attorney, are not entitled to any information regarding what the governor's office considers or how the governor makes a decision regarding the case. With the limited exception of juvenile lifers, the governor is free to approve or deny parole for any reason or no reason at all, and he is not required to offer any rationale for his decisions. The result is a process that frankly more closely resembles winning the lottery versus what should be a predictable and transparent process governed by the statutes and regulations set by this body. And that reality should concern all of us. The Maryland Parole Commission is the right body to make decisions about release that balance public safety and rehabilitation. In fact, the commission already makes decisions about release for individuals who are convicted of serious crimes, including second-degree murder. And I can tell you from my experience representing clients, often the difference between a first-degree murder conviction and a second-degree murder conviction is whether my client accepted a plea deal at trial. The commission is made up of 10 commissioners who are appointed by the governor and are approved with the advice and consent of the Senate. I'll tell you that the commission is not what anyone would consider a defendant or client-friendly body. About two-thirds of the current commission is made up of former law enforcement officials. And in my experience, commissioners give extraordinary weight to both the nature of the crime and any victim impact statement that is available. I want to close by saying I'm here today standing in for many advocates who have traveled to Annapolis over the years and if possible would be here today to urge this committee to pass Senate Bill 202. Governor Glenn Denning, who Senator Kelly mentioned, began the practice of refusing parole to lifers and has since publicly admitted that this position was wrong and politically motivated. He would have been here today to testify before the committee, but not for a conflict. He supports Senate Bill 202. This bill has never been more urgent. It's a matter of racial justice. I know this committee has received testimony in the past about the racial disparities in our incarcerated population. Those are real, those are problematic, but it's also a step the committee must take in light of the COVID-19 crisis. My colleagues and I in the defense bar have watched in horror in the past year as our clients, many of whom are elderly and have been recommended for parole numerous times, have contracted COVID-19 in prison and in some cases have been hospitalized. But not for the politicized nature of this process, they would have returned to their community years ago. When I approached the governor's office about a previously recommended client seriously COVID, he remains entirely unresponsive. This is not necessary to protect public safety, and his involvement poses a real issue for health and safety for people inside, and I urge you to issue a favorable report. Thank you.
Thank you, Ms. Meadows, and thank you for your work on this and many other issues. So looking forward to working with you in the weeks to come here. Next, Chair Kelly, we have Ms. Chaudhry. Zanab, you're up.
Hi, good afternoon. Thank you so much, Chair Smith and members of the Judicial Proceedings Committee. On behalf of CARE, the Council on American Islamic Relations, I thank you for this opportunity to testify in strong support of Senate Bill 202. CARE is America's largest Muslim civil rights and advocacy organization. As mentioned earlier by Senator Kelly, as you know, Maryland is only one of 3 states in the country that grants sole authority to the governor to make the decision on whether to approve parole for eligible Marylanders. Our state also leads the country in, unfortunately, incarcerating African Americans. In 2018, the Justice Policy Institute reported that African Americans make up more than 70% of Maryland's prison population, yet only 31% of the state's population. They also make up over 80% of people who have served the longest prison terms in our state. These staggering statistics illustrate the problematic notion that certain groups of people do not deserve compassion, that they aren't worthy of redemption, and they deserve to be isolated from society permanently. We respectfully challenge that notion. The Maryland Parole Commission was established under the Department of Public Safety and Correctional Services and charged with deciding whether Marylanders who are serving sentences of 6 months or more in state or local facilities are suitable for release under supervision on a case-by-case basis. The commission, as mentioned earlier by my colleague, looks at multiple factors when conducting an assessment on whether an initial parole grant hearing should be granted or not, including the nature and the circumstance of the offense, victim input, history and pattern of offenses, prior incarcerations, and much more. These decisions are not taken lightly. Appointments to the Parole Commission are made by the governor, as mentioned earlier. The governor should demonstrate trust in officials appointed under his authority at his command. They are more familiar with the circumstances and can better evaluate the readiness for release. But as of yet, for over a decade now, the state of Maryland has treated life sentences with possibility of parole the same as life sentences without parole. In addition to ethical and practical considerations, the incarceration of Marylanders serving life with parole sentences costs more than 70 million tax dollars annually. It's time to take the politics out of the decision to grant parole. This will ensure Marylanders who have demonstrated rehabilitation a fair, non-politicized parole granting process. It will help restore trust within the Parole Commission and enable our state to spend our tax dollars much more efficiently. For these reasons and those mentioned before, we strongly support Senate Bill 202 and we urge a favorable report. Thank you, and I yield my time.
Thank you very much. And next we will have Mr. McNeil. Calvin.
Good afternoon, ladies and gentlemen. My name is Calvin McNeil. On July the 8th, 2020, Judge White released me on a sentence modification after serving 4 decades for a crime I committed when I was 16 years old. I had been up for parole 8 times, and every time I went up for parole, the board always told me to keep up the good work, stay out of trouble, and don't get any tickets, which I did for over 25 years or more. So in 2008, the parole board recommended me for a commutation of the sentence. But while waiting for my decision, my wife passed away, and it hit me hard because she had hope that this would be the time that I would come home. But the decision came 3 years later, saying that I was denied by Governor O'Malley at the time and was given a rehear for 2016. 5 years more to wait. I could have given up, but that would have defeated everything I have been working for, my programming, my job at MCE, meat cutting, and everything that I have been telling the juvenile kids that came in and talked to us about my life and the decisions I had to make growing up. But in 2016, I went back up for parole, and the board recommended me again for commutation of sentence and an evaluation. Again, I had to wait 3 years and was denied on June 2019. And while waiting, I lost my parents and other family members. But in February of 2019, the full parole board have recommended me for parole. This time, the governor has 6 months to make a decision or let the parole board recommendation stand. But I was denied a second time. I feel that this process shouldn't be about politics, because when the judge and jury and the courts didn't find me guilty because of politics or sentence me because of politics, so why should any governor play a role in this process and make decisions on their personal political future? Let the people that you have appointed do their jobs. I just asked everyone to hear what I had to say, because it's a lot of men and women who deserve a second chance to show what they can do, like Judge White did for me. A week after I was home, I started to work at a warehouse moving and storage company. I've been involved with such family support groups, Maryland Parole Partnership, speaking at conference centers for education, justice, and resource. I thank you very much for your time.
Thank you very much, Mr. McNeil. Next, we'll have Mr. Green. Daryl, you're up.
Greetings, Chair Smith, Senator Kelly, and other members of the review, Judicial Procedure Review. Thank you. Again, I'm Daryl Green. I am a full-time professor at Morgan State University School of Social Work, but I will not be sitting here today in that capacity. I am the founder and principal consultant for Deep Forgiveness, which was born out of a tragedy that happened to my younger brother here in Baltimore City. My younger brother was killed over a pair of tennis shoes. He was killed over a pair of tennis shoes by a 14-year-old kid. He was sentenced to life in prison. After he served 25 years in jail, I went to court. My family and I went to court, and we testified on his behalf, i.e. we forgave him. Therein lies the name of our organization, Deep Forgiveness. We forgave him. Now him and I now work together. Everybody deserves a second chance. Everybody, I need everybody to hear this. Everybody deserves a second chance. You have men and women that have been sitting in jail for 40 years, 50 years, and as Senator Kelly said, some of them maybe even need to go to hospice. Listen, they deserve a second chance. Please take the politics, take the governor, Let the parole board do their job. And trust me, they've done their due diligence. When they bring folks up for parole, they have vetted these individuals. They've done their work. Let them do their job, continue to do their job, and take hold of their recommendation to release these folks today. So I stand here today in support of the bill support the bill of 202 to bring these men and women home. They've served enough time. They've served enough time. The young man who took my brother's life could have served 75 years. Guess what? It would never bring my brother back. But him and I now, we're now working together across the state of Maryland, across the country, and in some cases internationally, spreading the message of healing, reconciliation, forgiveness. And that would not have happened had he not gotten a second chance. The things that these folks have done is when they were young. We all on this call we are not the same person that we were when we were 15 years old, 17 years old, even 20 years old. We're 40 years removed from that. We're 50 years removed from that. Enough time is enough time, y'all. Please vote in support of this bill and bring these men and women home. They deserve a second chance. Thank you, and I submit back the rest of my time. I yield back the rest of my time.
Thank you, Mr. Green. And next, that concludes the hearing or the testimony from the proponents. We'll now switch over to the opponents. Mr. Schellenberger, I see you there. You are up next. Floor is yours.
Mr. Chairman, members of the committee, thank you so much for hearing from me today. You know, we've been here a lot of times on this bill, and I keep coming back to the same thing, and that is, you know, the governor, as the head of the executive branch, certainly should still be involved in approving an executive branch agency's decision whether or not to parole somebody. It's no different than if this committee passed a bill and suddenly it became law. Well, it doesn't work that way. If this committee passes a bill, it has to go to the entire Senate. And if the Senate and the House pass the bill, then believe it or not, guess where it goes? It goes to the governor. And it does not become law unless the governor approves. So this is merely, this is an extension of the way we work in the government all the time. Now, the other thing that I think is important is you all have taken great steps in the last year to fix some of these problems. Number one, in 2011, you passed a law that says the governor can no longer put this in his pocket. He has to make a decision, and if they don't make a decision within 180 days, then whatever the parole commission recommended happens. So that was a good, positive move. It forced people to make decisions. The second things that have happened is a lot of the people that we were talking about several years ago have now been released. We have over 250 people who are affected by the Unger case, whose convictions stem from the 80s and late 70s, 250 lifers who have been released as a result of the Unger case. In addition, because of some Supreme Court cases, namely Miller and Montgomery, there are another 250 juveniles who the Parole Commission have given a second look at so they could apply the factors that the Supreme Court said need to be applied in juvenile cases. And importantly, Governor Hogan has paroled 26 people serving life sentences since he's been in office. He's commuted the sentences of another 22 inmates serving life sentence, and he's granted medical parole to another 7. So now we're talking about over 50 individuals that this wasn't applying to before, that this governor has now paroled. I suggest that this is now, because of the way things have been working, it is now a solution in search of a problem. This problem does not exist anymore. This governor is paroling people. He's looking at it. The parole commission is doing its job. This is no different than the executive, the top level executive, making the most important decision. And that is whether first degree murderers, first degree sex offenders, and first degree rapists get out of jail. The other important thing is, it's still an anomaly. All right, last one. It's still an anomaly that at life, you get your first parole hearing at 15 years, less good time credits. But when you get second-degree murder in 40 years, you have to serve 20 less good time credits. I see this bill is trying to even that out, but why should you get a 40-year sentence, be eligible parole at 20, and a life sentence and be eligible for parole at 20? I recognize there was an attempt to fix this problem, but it certainly seems to me there should be a bigger difference, not the exact same thing. Thank you for the extra time.
Excellent. Thank you, Mr. Schellenberger. Okay, and with that, that concludes the testimony for Senate Bill 202. Now open it up for questions. I see Senator Castley, Senator West, and then we'll go over to Senator Heddleman. Senator Castley, you're up.
Thank you, Mr. Chairman. I guess first questions to Mr. Schellenberger would be, so looking at your letter, looking at the fiscal note, I'm trying to understand. So I guess sentenced to life for first-degree murder, which means that I intentionally killed somebody, just was not accidental, not, I mean, I intended to kill him and I killed him. So I get sentenced to life, but I'm a model prisoner. I do everything right. Under this bill, how soon could I get my parole hearing? Assuming I did everything, I got every possible plus, good boy thing I could do to get out early. How soon could I get a parole hearing under this bill?
Under this bill, you would have to serve 20 years less good time credits. That would take you down to about 17. So you would get your first parole hearing at 17 years. Now, candidly, Senator, I'm sure the others can shake their head. Oh, I've not seen anybody convicted of first-degree murder with a life sentence who's gotten out in their first parole hearing. But you would get, Ms. Meadows is shaking her head, but you would in fact get your first hearing at 17 years.
Okay, so we're the legislature. I can't control who people put on the parole board. They change. Maybe you get a governor in there who just loves parole and loves to see people go. So I have to assume that's going to happen. We're talking about, well, currently it's all retired cops and the kind of stuff, but there's no requirement for that. So if the parole board takes a sharp turn pro-defendant, and all that, we could have people they could kill somebody, intentionally kill them, and serve 17 years and be back on the street if the parole board was going to go along with it. Isn't that right?
That is correct. The parole board sits for a term of years. They're staggered, but that certainly could have a completely different parole board within a few years. And again, they're appointed by the governor. So we don't know who the governor is going to be in a couple of years.
Right.
And that's why I think this is an excellent check and balance.
Yeah, I mean, look, so a new governor comes in, we don't know who that's going to be. Some people get bumped out because their terms expire. A couple people die from COVID or whatever. So they get a nice number of appointees. Next thing we know, we change the tenure of the parole board. And I'm seeing first-degree murderers walking 17 years. That's not beyond the realm of possibility, right?
It is not beyond the realm of possibility.
Okay, so that's one big trouble to me. The other problem I got is there's the old adage in the law that tough cases make for bad laws. I'm listening to folks talk about, one gentleman who served 40 to 50 years. Sounds like he's a decent person. Certainly he merited the action of the governor in letting him free. We have people talking about 14-year-olds and hey, life changes. That's not every case. If we want to talk about actions for 14-year-olds, we want to talk about, hey, new laws when you get in that 40 or 50 range. That's not where we are. We're at a bill that says people could literally serve 17 years. And if that's not what we mean, then we're saying, well, that's not gonna, no. That's what your bill says. Your bill says I could deliberately slit somebody's throat, take them away from their loved ones, their family, their children, their parents, their community. This person may have been an incredibly valuable contributor to our community for decades and decades, but because of my own greed and selfish and hatred, I slit their throat and left them to die in a ditch. And then I served 17 years. I just find that outrageous, Mr. Schellenberger, that we would even be thinking about that, even conceiving of that, and then try to justify that by saying, well, I can't think that a parole board would do that. You just This bill says we would give them the authority. If I don't want to give you the authority to do it, then why am I going to do that? If we're going to say we would never want you to do that, well, then don't give them the authority. I mean, you disagree with that?
No, they do have the authority, and that's why I think there should be a elected official answerable to the citizens of Maryland to have to either approve that authority or deny that authority.
Now, in the federal,
that governor is answerable to the citizens.
okay. Now, in the federal system, they don't have good time credits. So if you say 20, it's 20. In the federal system, if I say life, what does that mean?
That means life.
It literally means life. You're not walking out ever.
Right.
You're going to die in there. You're going to die in there. Okay.
More likely than not. They do have a medical system that if you're very sick, they can let you out, but not many people get let out early in the federal system.
Okay. Well, people take federal law very seriously though, too, don't they? It's people don't mess around when the feds walk in. Okay.
When federal prosecutors talk to victims and they say 40 means 40, 40 means 40.
Right. Okay. Thank you very much. I appreciate your time, Schellenberg.
Yes, sir.
Thank you, Mr. Chairman.
Thank you, Senator Cassidy. So then we've got Senator West and then Senator Heddleman. Senator West, you're up.
Thank you, Mr. Chairman. First of all, Mr. Schellenberger, it sounds like an awful lot of people who are lifers have gotten been released. So we have 250 Unger lifers released. We've got 270 more under Miller and Montgomery who are having their sentences reviewed. The governor, it looks like he's pardoned over 50, not pardoned, he's released in one way or another over 50 people. How many people are left who are still in jail for life after all these releases and commutations?
Unfortunately, there are quite a few. I don't know the exact number. I can tell you that of the 270 lifers who committed their crime when they were a juvenile, many of them did not get out. They got their second parole hearing, and the new levels of elements were applied to them, where the Supreme Court said you have to take into account age and things like that and the juvenile brain. But I candidly admit that many of them are still in. But there are still a lot of folks in, Senator. I can certainly try and find that out from the Division of Correction.
Well, in about 2 weeks, we're going to deal with the bill I have, which would have something to do with people who are convicted and sentenced for jail for over 20 years as juveniles, and now they're coming up on their 20th anniversary. But we'll deal with that later on.
Yes, sir.
Senator Kelly, I guess the current system requires the governor to act one way or the other within 180 days of the report or the recommendation of the parole commission. Why? And that's fairly new. It's only been in operation for a couple of years. Why isn't that sufficient to bring finality to this?
And Chair Kelly, with that, unmute you. There's something on the screen that says.
We want not only finality, we want a lack of disparity. We want reasonableness. We want mercy where mercy is relevant. It isn't always, but the parole commission has worked on these cases, sometimes 2 or 3 years before they ever get to any governor. The parole commission is much more deliberative. It is dealing with objective facts. It's dealing with sociological studies. It's dealing with what a person's life really looks like at the point in time in which there is a petition in front of them. Governors are acting privately. They sometimes are acting because they're human beings based on what their next race will look like if they're running for the same position or for some higher position or a different position. So the two things are not comparable at all. The other thing is that when I think about young people especially, one person comes to my mind. I didn't discuss them in my constructive remarks, but I'm remembering a young man that I read something about him the other day in the press, that he was one of those who has been asking. I haven't been in touch in about 40 years, and he's been in about that long. But I remember his mother, who was a school social worker, his father was a medical doctor. When someone broke into their home, killed their dog, tied up his father, raped his mother, that child was never the same. He got into some trouble. Since he's been in about 40 years, he has earned a college degree. He's done a lot of good works, but nothing that he can do will turn around the fact of the young age at the time he was sentenced and the trauma that he experienced as a crime victim, as a 7-year-old child. His name, I'm just going to call it, was James Priest. I know that his mom died last year. His father's gone. Almost all of his family is no longer here. But things like that impact many young people who commit crimes out of passion or out of mental health crises related to their own having been victims of crime. And I'm just saying that a governor is not, when we elect a governor, we are not electing them to make this decision. And they shouldn't have to come behind the parole board, which has done a professional job, usually lasting 2 or 3 years, really looking systematically at all psychosocial and educational and other aspects of the parole seeker.
All right, well, I've got 2 more questions for you, so I'm going to ask them both together and then be quiet to answer both of them. First question is, we took some powers away from the governor a year or 2 ago, and we made the effective date of the removal of the power effective on the inauguration of the next governor. So my first question is, why haven't you considered making the effective date of this bill January 2023? And then the second question is, if the governor really wants to adhere to the view that life means life, why, when he's appointing members to the parole commission, wouldn't he simply ask his potential appointees, do you agree with me that life means life? And if they say no, the governor moves on to the next possible candidate. So those are my 2 questions for you.
Well, let me start with your last one. I don't know what's in the head of any governor or why he appoints the people that he appoints. I'm going to assume they all are doing the best they can. Everybody has some propensities to go in one direction or another. With regard to the fact that we've got a bill that becomes applicable with the ascension of the next governor, I don't think that what I believe is justice and what is mercy and what is deserved mercy in cases where the parole commission, not for everybody, has made the objective decision that we ought to bring the governor back into it, or that we ought to wait for something like, who else? Is it a convenient time for us as politicians, or for a new governor, or for an outgoing governor? That is not a variable that I think is applicable in this case.
Thank you for your answers.
Thank you.
Well, thank you, Senator West. Senator Hedelman, you're up.
Thank you very much, Mr. Chairman. I actually had the same first question that Senator West had, and I'd like it to direct it to Professor Meadows, though. My state's attorney did talk about how there are hundreds of people who have been released through the Unger case and others. I would like you to talk about kind of the very low rate, my understanding is, of any sort of recidivism from that population and others that have been released early. And 2, could you speak to whether you have any knowledge about how many people there are who would currently fit the qualifications to be released early?
Absolutely. So speaking to your question, Senator West's question, Senator Hedelman, there are over 2,000 people in Maryland's prison system today serving life sentences. About 300 of those are individuals who are serving life with the possibility of parole for crimes that they committed as juveniles. And about 400 of those 2,000 people are age 60 and over. So quite a large population of elderly individuals who are, of course, especially at risk in our prisons today, given the spread of COVID-19. And so that's sort of the population that we're talking about with this bill. Mr. Schellenberger is right. About 250 people were released under the Unger decision, which was a Court of Appeals case that dealt with the constitutionality of jury instructions. And I think the big takeaway from that is not that their release solved our problem with the parole of lifers. It hasn't. There are 2,000 people who remain incarcerated. The big takeaway is that we know that people who are serving life sentences for various serious crimes, who have served a substantial amount of time in prison, can be released safely. The recidivism rate for people who have been released under Unger, I believe, is under 3%, which in comparison to recidivism for other population in the correctional system is extremely, extremely low. And so the Ungers are great proof that when we release people serving long sentences, we can do so safely. And, the courts had decisions to make in Unger cases. They could have retried these cases, or they had to enter into plea agreements, essentially. And I know that a lot of states' attorneys, especially in Baltimore City, but across the state, really looked at similar factors to parole to decide whether or not they were going to move forward with trying to retry this case and impose an additional life sentence, or whether they were going to negotiate for a plea offer. And so we know how to evaluate these cases, and we know that we can release people safely. And, I just want to add that in terms of waiting on this bill, in my testimony, I said that it's urgent, and it is. I talked about 400 people who are over the age of 60. COVID continues to be a very real issue. We can't pass the buck on this any longer, given the circumstances.
Thank you very much. Thank you, Mr. Chairman.
Thank you, Senator Heddleman. All right, looking around the room for any other questions. I had one for Ms. Meadows, and we can talk a little bit more offline afterwards. But so you talked about the, I guess you expound upon the commission's process when considering, a parolee, a potential parolee, because you talked about the rigor, and then the governor's process, which is not standard. There's no standardization. It would vary from governor to governor. So I guess that you could speak to that a little bit. But then second is, so this bill raises the eligibility from 15 to 20 years. And I think, just if you could clarify, is that less dim? So 20 years, then you could add dim credits, good time, all that good stuff. What are your thoughts on making that a hard rule, like 20, irrespective of, not counting dims, 20 and 20, like 20 is 20, dim credits do not count. So I just wanted to get your thoughts on those two things.
Sure. So first, in terms of the process, I described what's a very vigorous process by the commission. And then when it goes to the governor currently, over both parole and commutation recommendations, exerts executive privilege. And so no one knows how the governor makes these decisions. And I think that that's so troubling, given that the parole process is governed by statute. There are factors that this body has deemed the right factors to consider when deciding whether or not to restore someone's liberty. And so I think that that's really troubling. But here's what we do know. We've heard a lot about how there's no problem here. People are being released under Governor Hogan. But what we don't talk about is the denominator for those numbers, right? How many people are being recommended and being refused, but also the fact that in 68% of the cases where someone has been released following a decision by the governor, there's actually been no decision at all by Governor Hogan. He has simply let the clock run out. And so the way this process works is a case is recommended to the governor. He has 180 days to make a decision. He can refuse the case in that time. He can take action and approve it, or he can simply do nothing at all. And when he does nothing at all, the recommendation of the Maryland Parole Commission becomes final. And so that's what's happening in 68% of these cases. The governor is doing nothing. And it's not clear to any of us whether that's because he's reviewed the case and just run out of time, whether he's not reviewing the case at all and the file is somewhere on the back burner. But I think a number like that is indicative of this isn't a process that the governor really needs to participate in. In 68% of these cases where people are being released, he's letting the recommendation of the Maryland Parole Commission become final. And so I would question whether or not he really needs to remain in this process if that's how it's working on the ground. With respect to diminution credits, Senator Smith, it's not quite as cut and dry as someone becomes parole eligible at 20 minus diminution credits, which could put them at 17. And shouldn't we just make that flat? I'm opposed to any process that takes away diminution credits. Those are earned through conduct in the institution. I think that if you were to ask correctional officers and correctional officials that question, they would say that diminution credits are an important tool for them in the institution to manage various things. But here's the other part of this. Parole eligibility, your first point of parole eligibility, actually is the gateway into many programs in the Department of Corrections. So there are many things that you cannot participate in, that you can't access, certain educational programs, certain cognitive programs, your security classification, being able to go from maximum security to medium security until you're eligible for that first parole hearing. And so when the legislature takes steps to push that parole eligibility further out, what we're really saying to people is you're going to spend longer in the institution without access to the things that could help you rehabilitate yourself. And for that reason, I'm opposed to making this a hard 20 and taking diminution credits out of the equation.
No, that's definitely helpful. We'll talk a little bit more offline about the programs that you're eligible for once you become parole eligible. So I definitely want to. That's great. Thank you for that. Just out of fairness, I saw Mr. Schellenberger wants to respond to my question, and then I know Senator Castley wants to chime back in. So, Mr. Schellenberger, there you go.
Thank you. And what I wanted to do was just fill in the gap on the governor's process. I can tell you that I regularly receive letters from the governor's office, typically his chief counsel, saying so-and-so has been recommended for parole. What is the state's position? And please send us the most recent address of the victim, if that is not, or the victim's family, if that is not already within the parole system, because they do try to contact the victim or the victim's family. I am regularly answering those letters. I can tell you that they reach out to the state's attorney for a history of the case and a recommendation on how they feel about whether that person should be released or not. I regularly correspond on that basis and send a written response. We have assisted the governor in finding victims' families so that they have contact and can also weigh in on that process. So that is the process that I'm aware of. I do not get the impression from the contacts I've had that it's some willy-nilly kind of thing. And while I respect the opinion that not deciding in the 180 days, this legislature, changed that. You forced the fact that if the governor doesn't make a decision, then what the parole commission recommended goes into effect. So I certainly think that was an improvement over what we saw back in the early 90s.
To your first point, I mean, I read your testimony, that's what prompted the question about the process. And, 2 thumbs up for the governor for, doing the deep dive and contacting your office. But I guess the underlying point is that there is no standard process, and that could change from administration to administration. And it could be a willy-nilly process. Vice, like the parole board, there is some rigor that goes along with that process. And that's
cannot disagree with you.
Yeah, fair enough. All right, thank you very much. Senator Castley.
Thank you. I just continuing on that line of questioning, Mr. Chairman, continuing on that line of questioning, Mr. Schellenberger has been involved with this process for multiple governors. Is it, we've heard that maybe the process might be willy-nilly. Have prior governors, it sounds like Governor Hogan has a pretty good process, and that 6 months from the parole commission is now done with it, transfer the file to the governor's attorneys, governor's people review it, governor's people send it back to you or whatever state's attorney it might go to. You review it, you contact witnesses, comes back to the governor's people. They have to get him on the calendar, review that. Doesn't seem like 6 months is exact. I mean, that's actually pretty efficient in many respects for all that to happen. But is it in your experience with prior governors, I mean, you've worked with at least 2, if not 3 or more, has this process been willy-nilly?
So I don't want you to date me back too far here, Senator, but it really has been Governor Hogan who kind of formalized the process. Prior to that, we would occasionally hear from the other governors asking for information, but it's definitely been much more formal since Governor Hogan took over.
Okay, that's helpful. And then if I just, a question for Ms. Meadows, are you, based upon what you've said already, it sounds like, I'm looking at the existing law, that you would be advocating then to return diminution credits for the folks that are currently denied diminution credits for people serving sentences for first-degree rape, second-degree rape, sexual offenses, and the like, right? All these sex offenses, the first-degree rape and second-degree rape, you would advocate that we should provide them with diminution credits as well then?
That's not the bill I'm here testifying on today.
No, I understand, but what you said was, we can be confident that, the diminution credits are coming back in. I mean, am I supposed to say, well, this person rapes people, this people slits their throats, but hey, doesn't the logic of diminution credits apply equally? So we should then be looking at that in the sex offenses as well?
I do think the logic of diminution credits applies equally, and I'm not in favor of exclusionary policies.
Okay, so the current law, you would be in favor of allowing diminution for good time for the sex offenses as well then?
I think that the nature of the crime is something that belongs in sentencing determinations. I think it guides how prosecutors charge cases and judges issue sentences. I think diminution credits are a Department of Corrections issue, and that once somebody arrives in the facility, everyone should have an equal opportunity for programming.
Okay, just curious. Thank you very much. Appreciate it. Thank you, Mr. Kramer.
Thank you very much. Thank you, Senator. And thank you, Ms. Meadows. All right, looking around the room for additional questions. Seeing none, Chair Kelly, thank you very much.
Thank you.
All our panelists. And with that, that'll conclude the hearing for Senate Bill 202. We'll now move on to Senator McCray with Senate Bill 254. Senator McCray, you're up.
Thank you, Mr. Chair. Thank you, Mr. Vice Chair, and thank you, members of the committee. For the record, my name is Corey McCray, Senator for the 45th Legislative District. I come here in reference to Senate Bill 254, Senate Bill 254. Senate Bill 254 would just simply give Maryland Department of Labor the opportunity to adopt standards in reference to our International Swimming Pool and Spa Code. These Maryland Building and Performance Standards would set a foundation, a minimum requirement that we can adopt for design, construction, alteration, and repair for swimming pools and spas. This legislation is not only supported by the fire chiefs and a number of folks that are inside of the industry, but it primarily deals with the health and safety and just making sure that we have some form of a standard around this specific issue. On the panel, Mr. Chair, you'll find that Jason Davison from the Pool and Hot Tub Alliance will be here, Alan Korn, the National Drowning Prevention Alliance, and also Sean Strasbaugh from the International Code Council, Inc. will be here testifying on the panel in respects to Senate Bill 254, and I hope that it gets a favorable report.
Excellent. Thank you, Senator McCray. And so for your primary witness, we have Mr. Davidson. So Mr. Davidson, you'll be given 5 minutes and the floor is yours.
Thank you, Mr. Chair. Can everybody hear me okay? Can everybody hear me?
You're good to go. Yep.
Oh, okay. All right, thank you. Thank you, Mr. Chairman, Mr. Vice Chair, and members of the committee. For the record, I am Jason Davidson, Director of Government Relations for the Pool and Hot Tub Alliance, known as the PHTA. We represent more than 3,500 business entities within the pool and spa industry. You may recall me from my time at SDAT. I worked closely with this body in 2020 on ground rent legislation. So it's really great to be back before this committee On behalf of the PHTA, we sincerely thank Senator McCray for sponsoring this very important bill. Building code consistency across county and state lines fosters compliance. Some Maryland counties have already adopted the ISPSC, most notably Montgomery County, Baltimore City. I know many of you represent those counties, as well as Carroll County and Frederick County have already begun to practice the ISPSC, although they haven't adopted it yet. But this is a great code and it's good for the same state and county adoption processes that is currently utilized for other building codes to ensure business-friendly climate that protects consumers. So Senate Bill 254 will bring uniformity statewide through the ISPSC, which addresses all aspects of public and residential pool and spa design and construction. It's also big on safety. The National Drowning Prevention Alliance supports this. Drownings have been a big issue. So this is a code that's going to help with drownings quite a bit. And just to be clear, under this bill, the ISPSC will only apply to new construction, new design, and certain renovations for existing pools. Operation and maintenance are not covered by the code and will remain with the Department of Health. You should have already received amendments approved by the Department of Health that clarifies this responsibility. And I just want to note that both departments under this bill are required to consult with each other in the implementation of this legislation. I just want to briefly touch on the opposition testimony that you received. We met with the Columbia Association prior to this hearing, and even before the hearing for the cross-file bill in the House. We came to an agreement that alleviated their concerns, and as a result of our agreement, there should be technical amendments coming to this committee very soon if you haven't seen them already. And just to note, over the last 4 weeks, we have reached out to all members of the opposition via phone calls and emails in an attempt to discuss the proposed legislation, to hear their concerns and come to a compromise agreement like we did with the Columbia Association. And just in regard to the Maryland Conference of Local Environmental Health Directors, we sent them the amendments which are supported by the Department of Health. We believe these amendments should satisfy their concerns. Finally, in conclusion, I just want to touch on the fiscal note. As I mentioned, Montgomery County, Baltimore City have already adopted this code. Carroll and Frederick are practicing. We haven't heard any feedback in regard to rising costs. And just to give you an example of what this code looks like, this is the code book right here. This is about as thick as it is. It's 50 pages. The Department of Labor maintains that there's a startup cost. Having served in state government, I truly believe the department can handle this with existing resources. So in conclusion, we ask for a favorable report by this committee, and I'm here to answer any questions if you have any.
Excellent. Thank you, Mr. Davidson. Good to see you. Next, we have Mr. Korn.
Thank you, Mr. Chairman, and Mr. Vice Chairman. Thank you to Senator McCray for sponsoring the bill. I'm Alan Korn. I'm the General Counsel for the National Drowning Prevention Alliance. I also represent lots of families who have been subject to water safety injuries and deaths. And let me be clear, not in the plaintiff's attorney sense or in their injury claims in the courts. Instead, as it relates to their foundations and their nonprofits that are mission-based for water safety. Given who I represent, there's no surprise that I'm supporting this bill, as are many of the families and the National Drowning Prevention Alliance. I also have a copy of the bill that I keep on my desk and refer to it regularly. The code, if adopted, would address lots of safety issues: barriers, sanitation, the health of the water, electrical safety, lighting safety, even signage at public pools. I'm not going to go through all of them. You'll hear about those things from other people who are testifying, and certainly the professionals who implement the code. I'm going to address instead just one of the particular safety requirements or safety benefits of this code that fills the gap with a piece of federal legislation. And let me take just a moment to talk historically. About 10 or 12 years ago, Congress passed, and President Bush 43, signed the Virginia Graham Baker Pool and Spa Safety Act. This may sound familiar. The catalyst for it was the death of Secretary of State James Baker's daughter by way of an entrapment in a pool. She was sucked to the bottom of the pool and drowned. That may sound familiar to you. Congress addressed the issue by passing the Virginia Graham Baker Pool and Spa Safety Act, which does lots of things for safety, including preventing entrapment. However, that particular legislation only applies to public pools. Congress did not feel it had the authority, the jurisdiction to address backyard pools in Maryland or Virginia or Missouri or North Dakota, wherever it is. So it's important for states to think about closing those gaps. This particular piece of legislation does that at least, or code, does that at least in part. It does for residential pools, new residential pools going forward, or pools that are substantially renovated going forward to comply with the same safety benefits as the Virginia Graham-Baker Pool and Spa Safety Act. I will note that since the effective date of the VGB Act, Virginia Graham-Baker Act, in public pools around the country, not just in Maryland, but around the country, there has not been a single entrapment death in the country. So it does work. I won't eat up too much time because I know we like to keep things brief. I have examples of what the drain covers look like, what a dangerous drain cover looked like, what the new required safety drain covers. Suffices to say, it is an example of government working on behalf of the safety of the citizens. And of course, we give an unqualified thumbs up to the adoption of the code. So thank you, Mr. Chairman.
Thank you, Mr. Corn. Next, we'll have Mr. Walker. You're up.
Hi, thank you for having me. My name is Alan Walker, and I'm the Vice President of Operations for Anthony and Sylvan Pools. I've worked for the company since 2005. We design and build residential pools in the state of Maryland, along with operations in 13 other states. I currently hold the Maryland Home Improvement Commission contractor's license for Anthony and Sylvan Pools. We strongly support the statewide adoption of the ISPSC in the state of Maryland. This will help bring all counties to a uniform level of code adoption, providing for a higher quality and safer product to the consumers of Maryland. A statewide adoption will benefit business by allowing pool builders to adhere to a uniform code, as opposed to different codes currently adopted at the county level. This will also ensure Maryland consumers will be getting the benefit of the most current safety developments and codes in a more timely manner. Thank you for my brief time, and we strongly support the adoption.
Excellent. Thank you very much. Next, we'll move on to Mr. Strasborough.
Thank you, Chair and committee members. I want to make sure you can hear me loudly and clear.
We can, yes.
Okay, thank you again. My name is Sean Strasborough. I'm the Senior Director of Plumbing, Mechanical, Fuel Gas, and Swimming Pool Programs here at the International Code Council. And I do serve as a subject matter expert for the International Swimming Pool and Spa Code, or what we'll reference as the ISPSC. Again, we come before you in support of Senate Bill 254, and we are thrilled to be joined by the diverse group of supporters, including the Maryland Building Officials Association, Maryland Building Industry Association, of course, the Pool and Hot Tub Alliance, State Farm Insurance, the Maryland Fire Marshals Committee, and the National Drowning Prevention Alliance, which you heard from a little bit earlier. This demonstrates good government through the adoption of safe, reasonable, and energy efficient provisions contained within the International Swimming Pool or Spa Code. Senate Bill 254 adopts the ISPSC by mirroring existing statutory language used to create the Maryland Building Performance Standards, and follows the same adoption cycle as the International Building Code, International Residential Code, and the International Energy Conservation Code as adopted under the current Maryland Building Performance Standards. This ensures that pool and spa design and construction continues to be coordinated and correlated with Maryland's other building regulatory provisions, and further solidifies safe, energy efficient, and updated construction practices. This legislation is timely as the Department of Labor is beginning their review of the 2021 codes for statewide adoption and implementation here in Maryland. While most jurisdictions in Maryland have some form of existing pool and spa regulations, most lack a comprehensive code that addresses design, construction, and the safety of pools and spas, again, leaving a patchwork of regulations across Maryland. Senate Bill 254 remedies this by adopting the International Swimming Pool and Spa Code, which is the only code that is coordinated and correlated with the other building codes, again, adopted in Maryland. We wish to stress that this adoption would not affect the operational provisions under the existing Maryland Public Pool and Spa law and regulations, as the ISPSC is only for design, construction, and the alterations. Senate Bill 254 does not require counties or cities to alter permitting requirements used for swimming pools and spas, but simply seeks to harmonize swimming pool and spa provisions across the state, providing contractors a foundation on which to build that again is coordinated with Maryland's building codes and most importantly, provides a safe set of standards that protects Maryland residents. Thank you for your time, and we ask for a favorable finding.
Thank you very much, Mr. Strasbaugh. So that concludes the testimony for the proponents. We'll now switch over to the opponents, and we have Mr. Jarvis. Is Mr. Jarvis here?
Yes.
Here you go.
Thank you. Thank you very much for this opportunity. I want to bring out some points here. I'm sorry, are you able to hear me, sir? I'm getting flashes on my screen. Oh, Jesus Christ. Am I there? Am I back?
You are, yeah, you're good. We can hear you.
I'm sorry, I just got cut off there. I'm sorry. Thank you for this opportunity. The information that is given is somewhat skewed, and I want to bring out a couple points. The bill has tremendous merit on the residential side of the bill. However, they're including the commercial side. They are implying that Maryland does not have a very good commercial law, which is 10-1704, COMAR 10-1704. 10-1704 has been adopted in 1992 when we had nothing, has been constantly updated, and is in the process now. The process started approximately 9 years ago when the governor at that time allowed us to have a committee to join the stakeholders with the state in writing these regulations. So with that in mind, I'm speaking primarily about the commercial implications of this bill. First of all, it creates a bureaucratic structure within DLLR, which is already in place with the Maryland Health Department. The bill forces non-code home rule counties to take up ownership of this. In the fiscal policy note, it noted the cost of this of approximately $96,000. But in fact, even with the footnotes of it, it mentions that it only speaks to those home rule counties that they talk to. The other 21 counties in the state of Maryland that do not have code home rule have no infrastructure, and the cost would be immense to have to set this up in each and every county. While filling a void in the residential market, it does not bring anything to the commercial facilities that are not already covered. The references that they offer, such as VGB, are already in COMAR 10-1701 and have been since its inception. And just for the record, the VGB law was created by the granddaughter, not the daughter. It was in a residential spa that was home built in a backyard, not a commercial facility at all. This bill also allows each county to create new requirements as they see fit. So we would have 21 different views of the law subject to interpretation. One of the biggest obstacles that we face in creating the code is uniformity, and in fact, has been passed in the last section of the legislature to become law very soon. This bill states that a code must be updated every 3 years from a national code, whereas we have the ability right now with the Department of Health and Mental Hygiene and the stakeholders to affect best practices as soon as they become available. The assertions that neighboring states have accepted this and certain jurisdictions in Maryland, but they have only accepted the residential portion of this. The facilities in Maryland are still under COMAR and have no right to assume this new law at all. And again, the physical policy, if you would read that, is extremely underestimated. As far as the code itself, this code has
Time.
to be, oh, sorry.
No, excellent. No worries. I'm always allowed to briefly conclude, but thank you very much. So seeing that that's the last witness, I'll turn to the committee for questions. Senator Jackson, you're up.
Thank you, Mr. Chairman. Thank you for the presentation. So I was looking at the bill. I'm trying to find, I saw, I represent 3 different counties. I saw one of the counties mentioned there. Calvary County. Could someone advise if Prince George's or Charles County is involved? And it's interesting that the last witness spoke that this deals with the residential, it covers the residential void in the market, but it has a challenge with the commercial market. So if the proponents could speak to that, I'd appreciate it.
Mr. Strasbaugh, I saw your hand was up. You can respond. I think you're unmuted.
Thank you, Mr. Chair. And in regards to the question raised, the two counties that you mentioned, to our knowledge, do not specifically adopt the ISPSC. I will note through the Maryland Building Performance Standard under the IBC, the International Building Code, and the International Residential Code, unless the jurisdiction specifically removes some reference sections, by reference, they may adopt the ISPSC. And again, to be clear, the ISPSC does cover both residential and commercial swimming pools. Understanding the Maryland Department of Health still has regulations written, which again, if I can answer that down the road, I will. The counties that are outlined, the 4 counties and the 2 cities have been working and performing plan reviews and inspections on public pools also in coordination with the jurisdictional health officials with no issues. In fact, working together in collaboration. So again, we feel this is not an over bureaucratic regulation that's adding additional layers on public pools. It's assisting. And again, I want to stick to the question that was raised and not go any further at this time. So I would yield to the chair then.
Thank you. If I may have a follow-up, Mr. Chairman.
Absolutely.
So for the counties who claim to not be specifically, well, I guess they have enough regulation in place to satisfy this, and so they don't fall under it. Ask you a question. If this were to become law, the effective date, are we looking at an emergency bill, or is that that's for everything going forward? And I guess my concern is for counties that are not involved or do not participate to this point, for the systems that are already in place, I guess they would have to have some sort of retrofitting, or how does it work in the industry?
Through the chair, Sean Strasbaugh here.
Yes, there you go.
Okay, I want to make sure. My understanding, and I believe it's clear in the bill, given that the Department of Labor has 18 months to promulgate regulations, and then jurisdictions through their adoption process have another 12 months to actually work through their regulations, which the bill does allow, again, mimicking the Maryland Building Performance Standards. Those jurisdictions alter the Chapter 1 administrations possibly to deal with the permit and how they deal with permits at their local level. And we want to stress that it still gives those local jurisdictions the ability to administer and amend those Chapter 1 areas for permitting administration of inspection of these public pools and residential pools.
Okay, so that alleviates the liability because the local jurisdictions are taken care of. Thank you, Mr. Chairman.
Fantastic, thank you. Okay, great. So Senator Castley, you're up next, and then Mr. Davidson, I'll get to you in a second.
Okay, thank you, Mr. Chairman. I guess my question really probably goes to Mr. Is it Strasbaugh? Is that, I don't know, I'm not trying to butcher your name. Is that, I just said it okay? Okay. So, you know, the whole theory of administrative law is that people in the industry working with government folks in the industry address matters in the industry, and you don't come before a committee. I'm looking around my committee members here. I don't think any of us has ever built a pool, designed a pool. Probably most of us have even maintained a pool. And the whole idea of administrative law is that we create bodies and they approve it's a technical matter. They work with the industry and the folks in the appropriate department and come up with the regulations. So why, and then we would only have to step back into the law if it looks like the governing, the section of the bureaucracy responsible for this is failing. I mean, people are dying, people are getting chopped up or something like that. And we realize that they need a little firmer guidance. Well, why are we being pulled back into this? I'm told that, listen to the testimony, the department's looking at amended regulations. There's a process going on. can you just, why now is the Senate Judicial Proceedings Committee, who just finished listening to a bill on whether we should keep lifers in prison and whether the governor should be involved in the parole decisions. Now we're looking at swimming pools. Maybe you can enlighten me. Why are we
Thank you. Speaking through the chair, I believe, Sean Straswell, International Co-Counsel. I'd like to point out one of the points you raised was the industry involvement, and the Pool and Hot Tub Alliance is the major part of the industry that is a partner with the International Co-Counsel on the development of the International Swimming Pool and Spa Code, which goes through an update every 3 years, which does incorporate safety provisions that we know come up. Things do come to light, new technology comes along. So that is part of the process at the national level, which we bring down to the state level for adoption. Furthermore, I'll note the previous testimony, and I think which you touched on was the current public pool regulations. There was notes brought up that they're currently looking at revising these regulations under the Maryland Department of Health, but they haven't for 9 years. When I went back, or when we went back and looked at the Maryland Public Health Rule regulations, some of the safety standards go back into the mid-90s. Again, the mid-90s. We're now in 2021. I won't dispute the BGB. That is federal law. It should be administered anyhow. However, the further suction entrapment avoidance safety provisions in the ISPSC go over and above the BGB for additional suction entrapment avoidance. So again, I want to make that clear. I believe the ISPSC relevant standards that are within the ISPSC are more up to date than the current Maryland Department of Health. And again, I don't know where they stand in their development. It sounds like they've been working on them for 9 years, but I'm not clear on where that is at. Here we have the 2021 ISPSC, and then again, subsequent additions that will come back before the Department of Labor every 3 years following, if you follow this legislative format, to be reviewed, and additional regulations written as needed. Hopefully none are needed then, but hopefully.
Yeah, I got all that, and that's interesting, but it really doesn't address the issue of why is this not a county level matter working with the appropriate department, and why does the General Assembly have to come back in? Because in most other areas, the industry will work with the state level bureaucracy to make sure the appropriate standards are put in place, allowing adequate flexibility for local needs, and then the counties adopt appropriate regulations that are commensurate with the state requirements. And now we're saying, no, that's not working here. And I'm trying to understand what's not working here, because I'm not hearing anybody, I'm not seeing a flood of swimming pool and spa cases where people are falling and slipping and being chopped up and dying. And I'm just wondering why don't we just let the current process work? And I realize you're saying, well, there's some better standards out here that we ought to be incorporating, but why isn't the industry working with the state level bureaucrats to incorporate those and push them through and work through COMAR? I don't understand why the system's working. Maybe Senator McCray can answer me, because I'm not.
Yeah, I will step in, Senator Castley.
Thank you.
I want to step in as an electrician that works in a craft, the only electrician out of the 188, and one of the few folks that actually work with my hands and not a lawyer within the respective General Assembly. So
there's not many of us, so we're
yeah, I got you. But I wanted to say, typically these bills, where I've always been the person that folks go to from a building standpoint, and I usually go through EHE. So this is my first time coming through JPR on this respective issue, but this is not unnormal. I actually have an electrician's bill where the local jurisdictions have always been in charge of that, but the uniform standard is what we're always trying to go for. This isn't anything new in building standards. The plumbers and steam fitters have already got it. But what happens when you think about this is because we have in respects to the health and safety piece of it. So the license or the standards that should be adopted are like the national standards. Same thing from the ISPC, the same thing with the National Electrical Code. These are things that are revisited on a continuous basis, not just like local jurisdiction by local jurisdiction have to look at it. These are things that are updated from a national standard, and we get the national standard put forward so that it automatically happens and that respective agency is working with them. What this bill does, it not just gets the Maryland Department of Labor involved, which always handles these types of things, and this isn't something new to them, but it also gives, and it sets the minimum standard from a state standpoint. The local jurisdiction can always set a more rigorous standard if they so choose. But the reality is that we have to make sure as a state that when young people, old people, all people alike are within public pools, residential pools, that they have that they have that safety that they believe that is supposed to be adopted for that. That's the same thing when we walk into any building, Senator Castley, we can rest assured that the fire alarm standards were met to a certain thing because the state of Maryland was thinking about this piece. So that's the same thing with this, is just trying to adopt a uniform standard across all jurisdictions and a minimum standard, and the local jurisdictions can always put forward more per se if they want to.
Okay, and thank you. I was just surprised that nobody in the bureaucracy chimed in to say thumbs up or thumbs down with this. It's all just a private industry, and you know, I'm used to counties adopting international building codes. I'm used to them being part of the COMAR. And I would really hope that whatever we're doing here, I have to look more closely, that we're mirroring what we're doing in the rest of the building code, and we're not doing things differently for pools and spas than we're doing for residential construction, commercial construction, whether that's electrical, plumbing, or any of the trades. I mean, I would agree it all be uniform. So, you know, I'm sort of taking by your response that this piece was sort of hanging out there, that we weren't treating them the same as all of the other trades. And now we're trying to treat them the same as all the other trades. And how I hear what you're saying, Senator McCray.
Yep, and let me be clear, electricians are still to some degree hanging out there. So we still haven't addressed that issue. And what happens is sometimes, as you stated, what happens, the General Assembly had to bring together, I hope that bill passed along with this bill, but sometimes the General Assembly have to be the convener of these respective folks that are in this respective industry, see where there's commonality at, see where there are differences at, and figure out a path forward.
So what about the other counties, Senator McCray, that they were discussing a minute ago, that this would be a burden on, that are not home rule counties, that how do you respond to that, those concerns?
I would think that the health and safety of folks across the state of Maryland are very important. And I think that there should be some form of a minimum standard. I think that the state has a responsibility when that isn't put forward, when folks are building pools, public pools, private pools, whatever they're building, we should have something in place for those respective local jurisdictions. I also would like to respect that if local jurisdictions wanted to put forward more stringent adoption rules, that option should be to them, but a minimum standard should exist somewhere within our space, because what happens when we don't do things like that, the young people, the seniors, and like I said, all alike that get into our pools, if something does happen, we as the 188 bear that responsibility.
All right. Thank you. Appreciate it. Thank you, Mr. Chairman.
Yes, sir.
Excellent. Thank you, Senator McCray, Senator Castley. So I see you, Senator West, but Mr. Davidson, did you have something that was responsive to that? And then we'll get you there, and then I'm going to move on to Senator West.
Yeah, sorry, I was trying to raise my hand, but Senator McCray covered a lot of the points. And Senator Castley, just to let you know, MACO and MML have thoroughly reviewed this legislation. They do not oppose this bill, otherwise they would have weighed in. I'd also like to point out that all the neighboring states, with exception to Delaware, so we're talking Pennsylvania, Virginia, West Virginia, they have adopted this code. And also many of the counties in Maryland either have, well, I listed the ones that have adopted it, but most of the counties in some form are practicing this code. This is just a minimum baseline standard that is enforceable only by the counties. The Department of Labor does not have the enforcement authority, the counties do. So this will still be left up to the counties. It's just a minimum standard that's already being practiced in the state. And that's why we feel this is important. It shouldn't cause any hiccups. The bill is written in accordance with the code, building code.
Excellent. Thank you very much. All right. So I want to close the loop on this. Mr. Jarvis, since your opposition, I want to just make sure we're balanced here, but we need to move on to Senator West's question after this. You're on, Mr. Jarvis.
Oh, I'm so sorry. Couple of things. This code is, by their definition, a minimum code. COMAR, as we have been working on, and many laws have been changed since 1992, has a much, much higher standard. I have a list of over 31 items, safety items, where presently COMAR exceeds this bill that's being presented. Because this bill has to cover commercial and residential, it can't possibly be held to the same standard. This bill prevents, by the way, any modification of a more stringent code. So it cannot exceed what is written right now. By their own definition, we cannot do anything that's higher. The one issue that was brought up about the lack of safety, as a pool builder and a member of the stakeholders, I can tell you that safety is by far our single most important thing. While the state may have some liability in an accident, let me tell you, the person that built the pool is going to be the very first one. We want stronger laws. We're weakening our laws. Secondly, this thing only moves forward. There was just a case in the legislature, Blackburn. It was in front of the Court of Appeals. A child fell into a pool and almost died. At the end of it all, it eliminates the grandfather clause. We are addressing that within the stakeholder committee very aggressively to bring everything up. This law does nothing to go backwards. Anything that's built up till now. So you're going to have two completely different levels of safety created by adopting this law. Again, it has great potential residentially. It is a very, very bad law commercially. The other states around us that had this had no code. So this is their first take at this. Maryland has been very active since 1992 in writing and updating this code. We are that far ahead of the other states around us that have adopted this code. I yield my time. Thank you.
Thank you very much.
Mr. Chair,
Yes, Senator, yes.
just because we're not sworn under any oath to tell the truth, I just wanted to make sure that folks look at page 3, line 11, section 12-204, where it gives the local jurisdictions the ability to set amendments to the respective standards that set by the Maryland Department of Labor. That's all, Mr. Chair. Thank you.
Excellent. Thank you. Noted. Thank you very much. Senator West, you are up. Hold on one second here. I'm going to ask to unmute you. There you go.
Okay. Am I okay now? Good, okay. I'm having a hard time with this bill because it looks as if here in Maryland, we have COMAR right now that has applied for many years and is generally being updated as time goes on to try to deal with Maryland's situation. And the proposal is, I think, to replace the current COMAR set of regulations with a brand new set of regulations adopted by this national organization. So, and then I'm trying to figure what difference would it make on the ground in people's backyards if we replace the current COMAR with the new regulations? So Mr. Davidson, maybe you could answer that. Could you give me several specific examples of things that would happen if we replace the current COMAR with this national set of regulations? How would it affect people's backyard pools in a way differently than the pools are currently being constructed under Maryland's COMAR regulations? We need to unmute Mr. Davidson, I'm afraid.
Yes, thank you, Senator West. I appreciate the questions. So COMAR is not going away. The COMAR will still be in place.
So we would have both sets of regulations operative, even if there are conflicts between them?
The Department of Labor and the Department of Health after this bill is implemented, will come together to hash out operation and maintenance regulations, as well as new construction and new design. COMAR does not go away. It is not weakened. These are just industry standards. It's not one standard being replacing another standard.
Well, then if I'm going to build a pool in my backyard, sounds like a great idea, frankly. But if I'm going to build a pool in my backyard, after this bill is passed, what would I have to do when I'm building my pool that would be different than if this bill were not passed?
Yeah, COMAR doesn't address backyards. It's public only. COMAR is not being replaced.
Okay, so your bill adds backyards to what's being regulated?
Sean, maybe you can speak to that, but what I understand is the COMAR is not weakened. It also doesn't cover backyards. Also, the department, like I said, the Department of Labor and Health are going to sort this out. There's a good 18-month period after this bill is implemented, and stakeholders like Mr. Jarvis can participate in the discussion with Health and Labor to ensure that everything is in accordance to the way it needs to be. Again, most of the counties are using this code in some form or fashion. These are industry standards. Also, in regards to safety, drowning is the second leading cause of death for children aged 0 to 5, and from ages 5 to 15, it's the third leading cause.
So, all right. So the current COMAR standards do not cover backyard pools, but your new standards, these national standards, are going to cover backyard pools, right?
Correct. And again, it's up to the counties to enforce. If there is a confliction with the ISPSC code and a county code, the county can move to fix that, and the county will win out every time. That is why MACO and MML does not oppose this legislation.
All right, I'm still not sure why this bill is necessary. But maybe you can just explain succinctly, under the circumstances, why do we need this bill?
Because in Maryland, it's just there's just a patchwork of code requirements. And speaking to the Department of Health, the department has not updated this code, the COMAR, in years. They've been talking about it.
But by your own testimony moments ago, you said if a county disagrees with elements of this code, they can change it. So aren't we still going to end up with a patchwork of code requirements?
Not, as you know, the geography of Maryland is very different. So what might work in one county might not work in another county. So right. They should be allowed to change that accordingly. Again, Montgomery
that sounds like a patchwork to me. And you just said the reason we have to pass this bill is so we can eliminate the patchwork of code requirements.
Again, these are industry standards that are not being used, that are not officially being recognized in Maryland, and are being used by various counties all over the state. And 3 other states that border Maryland, with the exception of Delaware, have adopted this standard.
Okay. All right. Thank you.
Thank you, Senator West. Okay. Looking around the Zoom room, seeing no further questions, that will conclude the hearing for Senate Bill 254. Thank you, Senator McCray. We'll see you later. That then moves us on to Senate Bill 63. Senator Benson, I see you're here. Senator Benson, you are up. Oh, yeah, unmute one more time here. Senator Benson, I think you muted yourself once more. We're going to do one more time here. There, oh, just it clicked on and then off again. I don't know what's going on. I click one more time. There you go. You're live.
I'm on.
There you go. We can hear you.
Thank you very much. Thank you, Mr. Chair, Mr. Vice Chair, members of this committee here, this wonderful committee. I am here this afternoon to ask for your support for Senate Bill 63, Marlow Heights Police Department establishment. It will detail the Marlow Heights Special Police Department's complete creation and duties. The Marlow Heights Police Department will not be an agency in Prince George's County. Thus, this will require help from the Department of Public Safety and Correctional Services and the Motor Vehicle Administration to aid with the police department's needs. Senate Bill 63 will establish the Marlow Heights Police Department and provide protection for the Marlow Heights community in Prince George's County and enforce applicable laws in ordinance and county regulations. The Marlow Heights Department will serve over 10,000 citizens and allow police officers authority to carry out, enforce, and make arrests. Major issues that the force currently faces are that officers must rely on their prior training from previous employment. Our communities must entrust those who are bound by law to protect them with proper resources and training. This means that a police status will need to be put in place to serve and protect the community's residents. The Marlow Heights Police Department will be well equipped to protect the citizens' welfare if provided the opportunity to receive the title and resources. We have to think about the safety of all residents of Maryland. We have to make the conscious decision to help eliminate crime by assisting the police departments and creating laws that will provide adequate safety that will protect and save lives. Thus, I urgently request that this committee give a favorable report for Senate Bill 63.
Excellent. Thank you, Senator Benson. And first we have Mr. Conklin. You are the primary witness, so you have 5 minutes, and the floor is yours, Chief.
Thank you, sir, Vice Chair and Vice Chair, and distinguished members of the Senate. Can you hear me? Okay. And also thank you, Senator Benson, for supporting us on Senate Bill 63. I'm going to kind of go off my testimony just a little bit because we don't have much time. First of all, we have been established here at Marlow Heights Shopping Center since 1950. We've been a police department, a special police department since 1960. We get our police authority under Title 3-301 under the governor of the state. We all get sworn, commissioned, and appointed to serve out our duties. That being said, we always want to think about community policing. There's been a lot of talk about that. So if you look at Marlow Heights as a whole, we are all community police officers. We have direct contact with our community, which is, like Senator Benson said, about 10,000 residents. Not only that, we have about 10 buses to 15 buses running daily, serving the shopping center as a drop-off point or to even come here. Now, the residents within the community rely on Marlow Heights Shopping Center for their vital needs, for grocery shopping, their medication, or just strictly entertainment. We need vital resources to bring our department up to date that were very costly, being able to allow us to apply for certain grants for certain circumstances, like training, also radio equipment, being allowed to get on to the county channel, which we can only listen approved by the county, which would be Prince George's County. Now I'm going to run by a couple quick stats that I have, and this will stretch from 2018 to 2020. In 2018, we had 1,452 calls for service with a total of arrests of 48 arrests. And then, and this is just brief, and I can provide all this more in detail if the committee would like so. In 2019, we had 2,133 calls for service with a total of 103 arrests, and that was 209 criminal citations, which is off of the DC 45, which is a arrest and a release back into the public. Now, with 2020, with the pandemic, the numbers are quite lower, of course, and that's a good thing. But we've had 1,161 calls for service with 16 arrests and only wrote 3 parking tickets. So usually, speaking about the parking, all our parking tickets, there's 230 approximate citations and parking. That money all is allocated to Prince George's County, where we do not receive 1 penny. It takes our resources, our manpower, our gas, our officers, and quite frankly, our time, but we do it. We make probably right over $500,000 worth of tickets a year for the county, in just this shopping center alone. Having Senate Bill 63 would absolutely help us when we send our officers to the academy, which they go to Montgomery County Municipal Academy, which is mandatory under the new current laws of 80 hours of training, which we extend that actually longer than that. We do other training as well, which ends up being a total about 125, 130 hours. I imagine in the future that will go up with the state of Maryland. But the biggest problem is I can just give you a quick example. It's like if you took your car to a dealership to get it worked on, you've got a qualified mechanic and they don't have any tools in their toolbox. And that's kind of where we're at. We've been doing this since 1960. And, you know, with the current days and times, we need to get updated. And we're asking for assistance to allow us to be able to apply for grants and to be able to get that assistance to serve better our shopping center and our community within it. And that being said, I would certainly hope that you guys would consider Senate Bill 63 is vital for the existence of many people in this area, and our officers dearly love serving this community. Thank you, Miss Senator Benson, for helping with this, and thank you, Senate Vice Chair. I really appreciate it, and I'm going to yield my time to Captain Paul Robillard, if that is okay.
Excellent. Thank you, Chief. And so now we'll move on to Captain Robillard.
Yes, sir.
Let's see. Is the Captain here? All right. Actually, Mr. Captain, can you, since you're on the same, you were muted, can you unmute yourself on that computer? I didn't know you were switching seats. Just unmute one more time, and then there you go.
Sorry about that, sir. Hear me?
You can. Yep, we're good.
All right, Mr. Chairman, Mr. Vice Chair, my name's Captain Paul Robillard of the Marlow Heights Special Police Department. This is my 20th year serving this department in this community and my 41st year in law enforcement. My tenure at Marlow Heights has been very, very rewarding and very engaging. Besides serving the shopping center, this department, as the chief said, serves a wide multicultural community. They depend on this shopping center for their household necessities, their apparel, prescriptions, medications, and even entertainment. We also cover outside and large apartment areas surrounding the shopping center that frees up the Prince George's County Police to allocate their services because they're very, very tight and overrun with calls many, many times throughout serving. I've seen families in my tenure here, including grandparents, fathers, mothers, children, grow up right in front of me. I don't know how anybody else could say community policing. That's the ultimate community policing, from little babies up to growing. I have a short story. Just a few weeks ago, I was in front of the Giant food store, and a young Marine in full uniform came up to me and asked me, "Captain, do you remember me?" I didn't remember him, but he proceeded to explain to me when he was 12 years old, he stole a soda and a bag of chips from a local store. Now, I responded on the radio call. He advised me comically that I was very stern with him and gave me some good life lessons. Well, here he is today, a member of the United States Marine Corps. The passing of Bill 63 will permit Chief Conklin and myself to move this department into the future, and we urgently need to go for the community and the center. I appreciate the time to give some quick testimony today. God bless each and every one of you, and God bless the great state of Maryland.
Any questions?
Thank you, Captain. All right. We have
Thank you.
one question.
Chief Commander, we'll stand together.
Yep. All right. So if there's any questions, we can take them or try to help out.
Jackson has a question.
Yes.
Thank you, Mr. Chairman. Thank you, Chief. Thank you, Senator Benson. Thank you, Captain. Senator Benson, I believe we've seen this bill in the past. As a former sheriff of Prince George's County, I certainly understand where the agency is trying to go, but I do have reservations as such that you all are sanctioned as special police officers designated to a specified area. And that, quite frankly, Temple Hills is not an incorporated area, Chief. So what you're asking is that, the owners of that property to be given authority through the Maryland Police Training and Standards Commissions to essentially have their own police agency. because your agency is
We
not
already have it.
Training and Standards Commission.
Can you hear me?
Yeah.
Okay, so we're already really established that. So we already are through the Maryland Training Commission. We have to do in-service, which is 12 hours at this point per every 2.5 years. We have to do the 12 hours of in-service. Plus, our new officers have to go, through the training through under Maryland police training to be able to even work with us. So there are steps and bounds that we take. Now, we do get our authority through Title 3-301 that gives us full powers of arrest on our property and, quite frankly, any property in the state of Maryland. So, for instance, we had property in Ocean City that's owned by the Gelman Group
Any property
Management.
any property that's owned by the Gelman Management.
Yes, sir. Yes, sir.
Yeah,
Only on that
special
property.
police officers, absolutely.
Yes, sir. Yes, sir. Only on that property. That's absolutely correct. But saying that, here at Marlow Heights, we've been here for so long, and this is our hub. This is where we stay. We do have other properties throughout Maryland, but this is our main area of operation right here. Our biggest problem, Senator, is we only got authorization. I'll just give you an example. Authorization to listen only on the county channel. Now, after 911, all law enforcement should be on a digital frequency to where they can change over or at least talk to the dispatch in case there is an issue. We're not on that, and we are considered law enforcement under Title III. We don't have that. We're only allowed or approved to hear the county. Now, that creates a huge safety issue, not only for us, but for the county surrounding us. We've had multiple occasions where that really caused the issue, along with not being able to communicate directly to the officer or to dispatch. They give us a number that we have to call in to dispatch. And now, Nick, can you only imagine, you being in law enforcement yourself, how that would play out if you're in a pretty tight situation trying to dial a phone number. So it just, we've been dealing with this for quite some time. And not only for the safety of our officers, but the safety of other officers, there's a big issue there. And also allowing us to be able to apply for certain grants, to help us with our training expenses, possibly equipment or that type thing that we desperately need to continue with our department going forward here in Temple Hills, Maryland. We're not trying to be a municipalities. We understand what our role is.
Let me say this, Chief. So I will, and Mr. Chairman, if I might. So I am opposed because of the structure that you're a part of to this bill and the establishment of you all as a police department. If there is an equipment issue or other factors that you have some concerns with, Chief, please feel free, either through Senator Benson or the chair of this committee or directly with me. I have some extensive tentacles that are out there in the public safety community and with the public and private sector in other regards to help you out with some of the other challenges that you have. So I am not unsympathetic to the role that you play. I shop at Marlow Heights Shopping Center. I grew up right down the street on Walters Lane. I live in Brandywine. So I think, let's have a conversation so that we can meet the needs that you have without, the county government has a responsibility to provide services. Owners have taken a step to provide services, but let's just see let's find out how we can address your concerns before we look beyond that. So that would be my statement. So please reach out to me. Thank you, Mr. Chairman.
Thank you very much. Thank you. Senator Sidor, did you still have a question? Okay, good. Senator Sidor, you're up.
Thank you, Mr. Chair. A few questions. I'm trying to understand, you mentioned a specific title that you all were created under, but from my looking at this bill, even I guess, I think you called yourself a special police department or something?
Yes, sir. Correct.
What's the relation to Gelman Management Company?
Okay, so I can explain that real easy. In the state of Maryland, of course, you have security guard companies, and we're not a security guard company. You know, they would do security, or, you know, in apartment complexes, or maybe in a shopping center, or wherever it may be. They could never be special police. They're not sworn. They have no powers of arrest. If you're a business owner in the state of Maryland, you can formulate and put together your own police department. And that was done actually here at Marla Heights back in 1960. Actually, we were special deputies back in those days, and we had transformed into special police officers under the state of Maryland, which is also under the state police. So that's what it had, you know, that's where it has went under over the years. And that gives us the powers of arrest to enforce laws on our properties that the Gelman Group Management owns throughout the state of Maryland.
Okay, so because I'm not familiar with Gelman,
Yes, sir.
I just went to the website. So you all have police powers. I noticed you all have that Gelman has an apartment complex in Bethesda, Battery Lane Apartments, and one in Chevy Chase, Maryland, the Strathmore Apartments. You all are able to exert police powers in those locations as well?
We haven't. What we have done, what the Gelman's management basically has done, we can. But what they have done is they hired contracted out security firms, which they do not have police powers. And we are actually only on this property, and we run to Riggs Plaza, which the Gelmans own that as well. So we protect the Marla Heights Shopping Center and Riggs Plaza right off of Riggs Road there.
But you could go to those other properties?
Absolutely, could. Absolutely, sir. Yes. Okay. Anywhere that the Gelmans own, lease, or own or lease property in the state of Maryland, we are the police on that property. That's absolutely correct.
And what do you get? I'm trying to understand, what is it that you get under this bill that you don't have?
Well, what would help us is, I mean, if you look at what we do outside of our scope, meaning we write traffic citations, so we help a lot of that. Well, all of that money on parking goes to Parking Authority that helps Prince George's County, which I understand a good portion of that money goes for their academy. We don't see any of that. We do about $500,000 a year for that. And then also we serve the community. To give you an example, not taking anything away from Prince George's County Police, because they're a fine agency, but you know, they get run thin a lot, and this is King sector that we have, and sometimes they only have police officers. Everybody in this community, the 10,000 residents that are surrounding us, know that Marla Heights is here if they have an issue. So we're getting a lot of that outside of our property on our property. Okay, and we address a lot of that and assist the county police with that.
Okay. And under this legislation, you all will be, it says Gelman Management Company shall be solely liable for the funding of the department. Are they?
Yes, sir.
So
we are already. So the Gelman Group Management is already fully responsible for this property and for our existence on anything that happens. Yes, sir.
So is there under your current framework I only have the the bill in front of me, so I don't know outside
Yeah,
of
no, I understand.
the bill. Is there anything that currently limits you all to the properties that are owned by this management company?
Well, I'll give you an example. Yes. So
I mean,
when,
no, I mean just within the law. So the law says, and I'm coming at this because just a few years ago we had a bill where this General Assembly granted Johns Hopkins University its own police force, and they had boundaries as to where this police department had the ability to police.
right.
And so I was wondering, is there anything in the law that gives boundaries?
Yes.
In terms of, okay. And
yes, there is.
Now
that would also allow me to interject for a second. So where our shopping center is located, we have the front of it, which would be Branch Avenue, the side of it, which would be 28th Avenue, and then also St. Clair. So what that also allow us to do is, if this bill was passed, I could go to Prince George's County and I could get a mutual aid agreement, and they could extend our authority out as far as they want. But I would assume it would be a few blocks from our shopping center, from where it is now.
I know one of the arguments that was made in order to support the Johns Hopkins Police Department was that it would be able to help Baltimore City's police department.
Right.
But what I noticed though is with this particular bill, Prince George's County actually opposes this bill. So it seems to me that they don't necessarily want the help. Would you mind addressing that?
I'm sorry, say it again, sir.
We have a letter of opposition from Prince George's County's, the Office of County Executive, in opposition to this bill.
Well, and I certainly understand what she's saying. And again, within our 33 acres here, our hub, as we call it, we get everything. And, me being in the street here, working the streets and coming up into the ranks, I've seen it all. I've seen everything, and what it would allow us to do is to give us a safe passage outside of our shopping center, okay, within a few blocks if we got a mutual aid agreement.
Right.
So
and I
now
hear you,
we are only.
But what I'm saying is I read this as they don't want you to do anything more than what you're already doing.
Yeah, and the thing of it is what we're doing is they're satisfied with, but it's not in writing. It's not in writing. I don't have a mutual aid agreement with the county. So basically, we eliminate county calls from the shopping center. They will call us, say, hey, y'all have got that, right? Yes, we do. So we eliminate all the calls from the shopping center and around the shopping center. But let's just give you an example. If I have a shooting that happens on Key Street, which is a block away, and there's no county units available, and somebody is there that's dying, so we're not allowed to run on that call. We will go on that call, but on a law standpoint, that is out of our scope. That is out of our area. And so if something did take place while we're trying to save a life or to help an officer that's in injury or fighting or doing something of that sort, that puts us in jeopardy because we're outside of our actual perimeter, which is the 33 acres, the roads that run parallel and beside it. Yes, sir.
Thank you. Thank you, Chief. I appreciate it. Thank you, Mr. Chief Conklin. I appreciate your help. Thank you.
Yes, no problem, sir. Yep.
Thank you, everyone, for your testimony and for answering these questions. So I just got host powers here and don't see any hands raised. Were there any other questions for these witnesses? All right, seeing no further questions. Thank you, Chief. Thank you, Captain. That concludes the hearing on SB 63. Thank you, Senator.
Thank you, sir. Thank you, sir.
We'll now move to SB 140. Senator Peters, you are up.
Thank you, Mr. Vice Chair.
This is a,
Keith Conklin. There we go. Go ahead, Senator.
there you go. This is a bill you heard last year. I think we ran out of time in the committee. The House bill passed and came over. It's a pretty emotional bill. I had a constituent approach me, and her son was tragically killed in a fire in a cab of a truck. He couldn't open the door of the truck. And after the investigation, the family found out that the company had a horrible safety record. The company has since gone out of business. And so what the bill really does is just allow any individual to access safety records of a company before they want to work there. And last year I had the Motor Truck Association oppose it. This year they are supporting it. So I just have two witnesses. I have the unfortunate, the mother here who is going to testify from her deceased son. And then I have the Lewis Campion from the Trucking Association.
Thank you, Senator. So it looks like our lead witness here for 5 minutes is Ms. Coran Fubert. Ms. Coran Fubert, are you with us?
Yes, I'm here. Thank you. I appreciate you all hearing me again this year. What I wanted to do is just kind of go over the purpose of this bill. As Senator Peters stated that, my son was killed in a fiery crash, but the real issue for this bill is that to enhance the safety standards, the requirements for individuals who drive CDL drivers. What this bill will do is it will promote transparency so that drivers can make informed decisions about whether or not they want to work for certain said employers. Prior to my son's death, his employer had a number of violations, and James only worked for this company maybe 3 months before he died. He had just finished CDL driving school, the year before. This company had numerous critical violations dating back to 2015 when they started. When they started in business, over time, they had only had 10 inspections, and 9 of those 10 inspections failed. And it was for numerous serious things. My son had been trying to get this employer to fix the door handle on his truck prior to his death. The truck had broken down already in New Jersey. He had to tow it back himself and a friend. And so it was just numerous issues that were going on. But even though I'm a medical provider and I've served in Prince George's County for a very long period of time, as a medical person, I have 3 degrees. I'm certified in occupational health and safety. And I say all that, even with all of that training, I was not aware or not able to easily access the safety information on employers for these particular said companies. It could easily be said that they have their US DOT numbers on the side of their trucks, but this bill really gets to a little bit more of the heart of this, because this was an employer who did not comply with alcohol and drug testing programs, did not comply with safety at all. And it is really a preventable death. And for example, you'll say, well, maybe why are we really looking at this? This is an employer who now, according to their records, they're out of business as I looked yesterday, but it looks like there's been 2 deaths before we can move this bill forward. But what this would allow is that, for example, if you're going to work for an employer, the Federal Motor Carrier Safety Administration, they have a website. It's a safer site, which I'm sure Lewis will discuss as well. It's on that site where it will tell you things like if you're getting a job, you can look and see if the person is out of service, it's up to date by the hour. And what it'll tell you what their violation summaries is. And this is important because of a number of things. If an employer already has deaths or safety violations, brakes not working, doors not opening, etc., we may have all that from a federal level, but when it gets to the state level, at the state level, we're not really overseeing that as closely. For example, this company was still operating on another business name, even though it wasn't compliant in the current business in the state of Maryland. So what we want to do is have them, one, tell the potential employee up front what the safety website information is, what their safety record is. What you can go there and look on that site is 3 critical things. Their violations, you can tell if they're insured. This company also had multiple lapses in insurance, even just 2 days or so before James died. So if he had actually died when the insurance was lapsed, he would have had no coverage, et cetera. And that would be for all of them. In addition to that, if an employer looks and see that a company has already had multiple deaths or multiple violations, they may make a decision that they really don't want to work for that employer. But so that's why I feel that this bill is important. When you have a company who is 90% failure out of 100, it shouldn't take us 5 years to do something about that, and for them to continue operating and us not prevent our children from dying. Because you got to remember that the CDL drivers, they're generally as a trade, they're maybe undereducated, they really need to do their work. The employers in the position of controlling their schedule, et cetera. And the day my son died, he wasn't even supposed to go to work. So he was called within 4 hours, and then he drove 10 hours and died at 3 a.m. in the morning. And again, there's no accountability or responsibility really at the lower level. So I would really like to ask you all support. It's, it's never easy to do this, but I really hope that I can prevent another child from dying, or brother, sister, because of a preventable type of case. And so I hope that I've gotten all of my points across, and I really just appreciate you all's time. I know James' picture is in, you have the law in from last year in the data files, et cetera. So Lewis, I hope I've covered, and what I did not cover, hopefully you'll cover for me. So I really appreciate it.
Thank you, Ms. Ferber. We really appreciate your testimony and know how difficult it is for you to be here. Lewis, we'll go to you in one moment, but before we do, is Ms. Ethel Corin also testifying? Okay, she is.
What did he say?
I'm sorry, is Ms. Ethel Corin also testifying?
That's me. My name is Ethel Jackie Coran. I got married, so I have a Ferbert on my name, but most people just know me as Jackie Coran. And I wanted to keep the name so you would know it's affiliated with my son.
Got it. Okay. Thank you so much for that explanation. Mr. Campion.
Thank you, Mr. Chairman. Again, Louis Campion with the Maryland Motor Truck Association, with more than 1,000 trucking companies as members across the state. And we are here in support of this legislation. And really appreciate the testimony of Mrs. Coran. The reality is what happened to James Coran should never have occurred. There are literally hundreds of thousands of trucking companies in this country that are safe, compliant companies that operate quality equipment, and they're in desperate need of truck drivers where there's a severe shortage. And sadly, the company that Mr. Coran worked with, as you've already heard, was not one of those companies. And if you know where to look, right, it can be very easy to see what a company's history is. But if you don't know where to look, it can be very difficult. And so that's what we're trying to do with this legislation, is that when a motor carrier makes an employment offer to a driver, then he gives him that tool, right? It gives him his DOT number, and he gives him the website address for the federal database where you can find everything from inspection history, crash history, safety record, insurance information, that company's authority is up to date, what types of cargo they're registered to carry, all so that ultimately drivers can make an educated decision. Is this a company that I actually want to work for? And so, the ideal circumstance is that drivers will avoid working for subpar companies that aren't safe and that have those subpar records. And then in turn, it really benefits the legitimate safe trucking companies who are looking for those drivers. Because when I talked with Mrs. Scran, we talked several times last year, at the end of the day, it saddened me so much that her son was working for this company, because we could have easily connected her with so many better or him with so many better opportunities. And we think this bill helps give drivers a tool that will allow them to do that. And so we ask for a favorable report.
Thank you, Mr. Campion. Senator Carter has a question. Senator Carter.
I can't hear her.
I think she's muted.
Oh.
So Senator Carter, I've clicked the ask to unmute. There you go.
Thank you. I know, I think I'm too fast, like on the floor, like I pushed too fast. Anyway. So I wanted to say thank you for your testimony, Jackie. You said it was okay to call you Jackie. That's what you are, so I'll call you that. I appreciate the bill. I have a lot of empathy for you. I remember feeling the same way last year. I do hope that we can do something. So I have a comment and a question. Also, thank you, Senator Peters, for bringing the bill, which is that I just feel that this isn't, I definitely I could actually vote yes in favor of the bill as it is, but I actually feel it's not enough.
Right.
I think that in drivers' desperation to get employed, they might just ignore the prior safety history and say, I'm going to work there anyway because I need money right now, I need a job. Or I'm waiting for something else to come in, and while I'm waiting for that, I'm going to take this in the meantime. It won't be forever. I'm wondering why we can't do something a little bit stronger, like prohibit companies with certain violations from hiring or for a period of time or something like that. Something where the onus is more on the company to be safe and not put people in jeopardy, as opposed to making it the onus on the potential employee to go and look something up. Because honestly, if you need a job and you desperately want money and you have to feed your family, you may say, I know this company has a really bad history, but I'm going to take the chance because I need work right now.
Mm-hmm. Mm-hmm.
What do you think about that? And
I agree. And I, you know, honestly, I wake up every day feeling like the bill isn't enough, you know, but I know it's a start to being able to do something. But I do think in Maryland, because, you know, we are a very good state, we're very well regulated. And I do feel that there is no reason why we couldn't at a state level set up a model program where it is monitored at the state level, where, you know, you have a company that's out of service. If they got several different EIN numbers, they just move to the other company and work, and they're still utilizing the same trucks. And as I said yesterday, I looked on this website, it now lists that there's 2 fatalities with this same company. So, you know, there's just no accountability, and there's really no tracking at the state level. You know, we can't expect the federal to enforce what we need to enforce at our state level, because we know that people will not check themselves, because, you know, it's also about money. You know, when there is, you know, the whole purpose in having a trucking company is to actually drive that truck, and you may cut corners. But I think we shouldn't, if the state in some sort of way, even in some minor way, if we looked at the accountability of the bad players and stop them from allowing drivers to drive. You know, when you got a truck in the state of Maryland that's got an out of service notice from the Federal Motor Carrier Association, there's really nothing right here in the state that will stop them from driving. There is no penalty.
So I do want to actually interject, because I think that some of the statements are not actually accurate. There actually is a very aggressive commercial vehicle enforcement division within the Maryland State Police. In fact, we do the most amount of inspections behind New York, Texas, and California of any state in the country. I think what you get at is there is a process for audits that are done both by the Maryland State Police Commercial Vehicle Enforcement Division, also by the Federal Motor Carrier Safety Administration. They actually work hand in hand, and there are time periods within which a company has to be audited. There are various triggers that cause that audit. I think and numerous laws that would put this company out of service. The challenge is always going to be, like any law enforcement activity, is resources.
Well,
right?
too, it may
So,
be then that how do we target, how do we trigger, they're tracking, and I agree with you, and you and I talked about the inspection process, because when they do stop and they go through the inspections at the various stops, that the detailed inspection is not really done. And also a lot of that is the drivers don't know who to report a real problem to if the employer does not fix it. But getting at the point of at the state level, if at the state level, then we should have a mechanism at the inspection level where if you got a company that is 90% out of compliance, that company should have a red flag. It shouldn't be a routine audit, because this company in that from 2015 to 2021 or 2020, they only had 10 inspections. Of the 10, they failed 9. But we, at our level in the state, that was a red flag. And so the question would be, then maybe we need to be focusing not on the inspections, not on the people who are in compliance, but the people who are not in compliance and getting them, because that's where your workers are going to die. Because we've had on average about 5,000 deaths a year. And in 2018, from 15 to 18, we've gone up from really 8% to 11%, death rate. Now that would include the big trucks as well as the buses. But the fact is, one death is too many, when we know it's something that we could make a positive change. So Lewis, from you, what do you suggest versus being disagreeable? What can we do better?
yeah,
Actually,
so I think, I'm
I wanna
sorry,
be-
Mr. Chairman, go ahead.
Yeah, so I want to make sure that we're not here, in kind of a work session on behalf of the bill. That will happen later, and we'll make sure that this bill reflects the values that you are each talking about here today. Senator Carter, did you have a follow-up question?
I did. I just want to say I appreciate it. I was going to say the same thing that, as it's been said many times, we sadly, in these situations, we ask the questions. But I wanted to just ask Senator Peterson, you don't even have to answer. You can head nod if you'd like. Would you be interested in working together to try to maybe not only pass this version of the bill, but maybe even look at how we might strengthen it to give it more teeth? Thank you.
Thank you.
Well, thank you all for coming forward with this bill. Senator Peters, thank you for bringing, Senator Bailey, I see you have a question. Go ahead, Senator Bailey, you are unmuted.
Thank you. Thank you, Mr. Chairman. I did have one question. Having and still keeping a CDL license and going through a semi-annual actual doctors, when you go in for a physical and making sure that you pass your DOT physical, it's interesting for me to know that if people that have a marijuana card in Maryland can no longer qualify to have a CDL.
Mm-hmm.
But when I was at my recent physical last summer, I visited with the doctor and he had a stack on his desk of commercial driver's license applications that he was having to work with that were thick. And he said, and I said, well, what are those? And he said, ironically, he said, they're all the people that are designated opioids that have been given by a doctor. And I said, they're commercial CDL drivers. He said, absolutely. Now, when you test for a CDL in Maryland, you have to take a urinalysis and they test you for marijuana, but they don't test you for anything else. Just something as we move forward with this bill, something to think about.
Mm-hmm.
Thank you, Senator Bailey. Any other questions for these witnesses? Well, again, Senator Peters, thank you for bringing everyone together on this bill. Jackie, thank you so much for sharing the story of your son, again, with this committee. And Lewis, thank you for your testimony as well. That concludes the hearing. On that hearing, we'll next move, on that bill, we'll next move to Senate Bill 23. Senator Hedelman, you are on.
Thank you very much, Mr. Chairman. My name is Shelley Hedelman, and I'm Senator from District 11, Baltimore County, and I'm here to present Senate Bill 23. The purpose of Senate Bill 23 is to remove the financial obligations from those who are presumed innocent and awaiting trials and who are deemed unable to pay by the Office of the Public Defender. We all know that COVID has certainly had an impact on our pretrial population. And one of the impacts has been an increased use of pretrial home detention in an effort to limit the spread among prison populations. As well, over the past few years, in an effort and in responding to our bail reform efforts, many defendants are being released to home detention and are required to wear home monitoring devices. These are people who are charged with, but not convicted of any crime, and we believe they should not bear the financial burden of their monitoring. This puts low-income defendants in an impossible situation. While they await trial, and as we know, those are often lengthy delays these days, home detention can likely mean that they're unable to earn a wage. Requiring them to pay for their monitoring may put them in debt and force them to choose between paying for essentials such as rent and childcare, groceries, and healthcare, and paying to remain outside of jail. And if they don't pay, they could be in default and have to go back to jail. This bill is an extension of an effort to end the wealth-based pretrial detention system that's criminalizing poverty. I am proud to say in my home county of Baltimore County, our county executive recently announced that the county was going to stop charging pretrial defendants for their monitoring. I want to take a little bit of step back in time to 2017, when we put quite a lot of effort, and when I was on the House side, I was involved with this, on bail reform. And during that period of time, the judiciary adopted a Rule 4-216.1, and it had to do with the standards governing pretrial release. And at that time, the judiciary talked about the need to provide an individualized assessment for defendants. It was designed to promote the release of defendants. I'm reading directly from the rule now. Designed to promote the release of defendants on their own recognizance or, when necessary, unsecured bond. Additional conditions should be imposed on release only if the need to ensure appearance at court proceedings, to protect the community, victims, witnesses, or any other person, and to maintain the integrity of the judicial process is demonstrated by the circumstances of the individual case. Preference should be given to additional conditions without financial terms. We believe that this bill would go a long way to removing those financial conditions, and would also go a long way to decriminalizing poverty. So I thank you, and turn it over to my esteemed panel.
Thank you, Senator. Ms. York, you are the designated 5-minute witness. And so 5 minutes, Ms. York, please go ahead.
Thank you so much. Good afternoon, Mr. Chairman, Mr. Vice Chairman, and members of the committee. For the record, I'm Karen York, Chief Executive Officer of the Job Opportunities Task Force, better known as JOTF. My remarks today are in support of Senate Bill 38 as a means of continuing the unfinished business of eliminating a wealth-based pretrial system in Maryland that continues to penalize individuals who are poor and overwhelmingly Black. The debate over pretrial reform is not new to Maryland. It has been discussed, debated, and reformed since the 1970s to most recently 2017, that resulted in a landmark rule change in pretrial that Senator Hedelman, our bill sponsor, just referenced. The rule change was a game changer in our courts and on the streets, but we knew the fight was far from over. Indeed, we predicted and saw an increase in persons released on their own recognizance, but we also predicted and saw an increase in defendants held without bond. In 2020, the pandemic hit. Efforts to reduce local pretrial populations were revived in every state across the country, given the fact that jails and prisons are hotbeds for virus transmission. Coupled with protests and subsequent pretrial arrests, bail funds were created and enhanced. In Maryland, a generous anonymous donor reached out to a number of agencies, advocates, and partners to offer $500,000 to create a formal bail fund in Baltimore City. JOTF was asked to host the bail fund, and since May of 2020, we've partnered with the Baltimore City Office of the Public Defender, Baltimore Action Legal Team, and Out for Justice, from which you'll hear today, to one, support the release of nonviolent city residents incarcerated on an unaffordable cash bail, ensure their appearance at court, which also ensures reimbursement of their bail funds, and facilitate their successful reentry post-trial. We're currently exploring a creation of a local fund in Montgomery County at the request of local partners as well. Yet over time, we found that this fund could not be limited to only unaffordable cash bails. We had to expand to costly home detention fees. The cost of home detention is the responsibility of the defendant, many of whom have low or no income and are overwhelmingly Black. In counties that do not provide monitoring services, the defendant must work with the private monitoring companies. These are unregulated agencies that can set their own rates and have effectively filled the role of bail bondsmen. Daily rates can range from $10 to $30 per day. One client's grandfather is paying almost $300 every 2 weeks. He's on a fixed income. The 20-year-old grandson is working to secure his GED and is unemployed. And we know that securing employment is particularly challenging without a high school diploma, criminal record, and your own home detention. To be clear, if the defendant defaults on payment, it is considered a violation of the home detention order, which could result in incarceration. Home detention does not work with you on payment. They don't help you get a job. They want to make sure you pay your money on time, the end. Pandemic-related court delays saw more individuals assigned to home detention. Postponements mean defendants or the organizations assisting them have to pay more in home detention. One client assigned to home detention on November 24th, 2020, doesn't have court until June 2021. His total balance until June is over $1,400. JOTF has paid $715 for him thus far to cover the past due balance. In our own construction training program, we're finding that our clients on home detention monitoring can't afford the daily fees and the monthly fees in addition to the setup fees. They are unemployed, trying to secure employment in the construction industry, but expected to secure employment while on home detention, which imposes restrictions on movement and hours outside the home, which we know is tricky with the criminal record and on home detention. So we have to step in to cover the costs for our training participants. How is this happening? Because the rule isn't being followed. As Senator Hedelman mentioned, on page 34 of the rule, in no uncertain terms, does it say there is a requirement that individualized considerations must be made along with a specific inquiry into whether the defendant can pay any financial terms. Simply put, the Court of Appeal ruled that ability to pay determinations must occur. This provision was not limited to cash bail, but all conditions of release where the defendant must pay and their freedom could be at stake. So I urge the committee to remember that courts around the country, including our state's highest court, have established that pretrial conditions that are unaffordable and potentially tied to one's freedom are blatantly unconstitutional. This is the fourth year this bill has been introduced. It's a direct recommendation of JOTF's 2018 report on the many ways Maryland policies are criminalizing poor communities of color. This was an issue in 2018. In 2019, and the pandemic has exacerbated the issue in 2020 and 2021. Senate Bill 23 is a step closer toward the goal recently realized in Illinois, an end to wealth-based pretrial detention. We look forward to working with our bill sponsors, advocates, practitioners, and committee members to ensure home detention monitoring is covered by the state and/or locals and not the defendant, particularly indigent defendants, ensuring a cap on how much private monitoring companies can charge for home detention monitoring. Currently, they can set their own rates, and eventually moving closer and closer and closer to actually removing money out of pretrial. We urge a favorable report. Thank you.
Thank you, Ms. York, for the wonderful testimony. Mr. Oppenheim.
Yes, good afternoon. My name is Todd Oppenheim. I'm a supervising attorney in the Public Defender's Office of 17 years. I have clients on home detention. I'm very familiar with the process. No one awaiting trial, presumed innocent, should be incarcerated based on their financial circumstances. Basically, what we have now is that you cannot be released on home detention if you can't afford the fees. And if you're on home detention and you get released and you miss payments, you can be rearrested. It shouldn't be that way. So what Senate Bill 23 does, it offers a fix in two very important ways. It immediately addresses the problem by providing quick relief when enacted, which of course is still months away during this pandemic. So by offering funding to indigent individuals to either provide home detention fees or cover local fees. This is huge. Remember, home detention is still a version of incarceration. Individuals can't leave their residences except for approved allowances. Many of our clients are on quote unquote 24/7 lockdown. Home detention can mean the difference between life and death during COVID as it makes its way through our jails and prisons. So being at home allows people to properly sanitize, mask, and socially distance. We've also seen unprecedented delays, up to 1.5 years for clients who are pre-trial awaiting trial. So this should be regarded as a humane response to the pandemic. Secondly, as Ms. York alluded to, this is an extremely important step for the legislator to take towards reworking an uneven pretrial system throughout the state and really complete the reforms that were started in 2017 towards bail. In our opinion, people arrested in jurisdictions like Kent County or Baltimore City without free home detention in those places are subjected to equal protection violations in that they don't have the same options of release as individuals arrested in places like Montgomery, St. Mary's, Anne Arundel, or Prince George's County, where home detention is local and most importantly, free. So providing funding levels the playing field. It's also of great significance that OPD clients across the state struggling with home detention costs tend to be people of color. Neither your place of arrest, financial wherewithal, nor race should determine whether you're held in jail as you await a court date. So we ask for a favorable recommendation from the committee.
Thank you, Mr. Oppenheim. Ms. Freeman, you are next today.
Good afternoon, Chair, Vice Chair, and members of the Judicial Proceedings Committee. My name is Iman Freeman, and I am the Executive Director of the Baltimore Action Legal Team. On April 2nd, 2020, an attorney from the OPD reached out to Ball asking if we could cover the electronic monitoring fees for a juvenile charged as adults. Since that email, we have paid over $100,000 to 2 private home detention companies in the Baltimore area. And to be clear, it's $100,000, over $100,000 of the community's money raised from people like you and me. We took on clients who could not afford to cover the cost of court-ordered electronic monitoring. If BALT had not raised these funds from the community, 131 Baltimore residents awaiting trial may have remained in jail during a global pandemic. Let's be clear. People are being required to pay for the state to monitor them during a global pandemic and while people are losing their jobs every single day. This is the very definition of criminalizing poverty. After assisting the people of Baltimore for over a year, almost a year, BALT has had a first row seat into the process, or lack thereof, of electronic monitoring in Baltimore City. Many of the people that come to us were given the choice of electronic monitoring or go to jail. We get frantic calls from those impacted directly or their families asking if we can pay because they cannot. And this is always after the judge has ordered electronic monitoring as a condition of their release. Community members often get our numbers from their attorneys or the electronic monitoring company themselves. I'm aware that the fiscal note for this bill assumes most individuals currently being monitored by these companies are not indigent due to the assumption that the company is requiring a demonstrable ability to pay for services. Not only is this an incorrect assumption, it's just not true. Impacted individuals show up to the agencies within 24 hours of being released. They sign contracts taking financial responsibility for GPS equipment. They pay fees for background checks and urine analysis. They get hooked up to a GPS ankle monitor and pay for the first 2 weeks. They need to return every 2 weeks to continue to pay cash or check in person or face extra fees for paying remotely by credit card or PayPal. However, these companies allow BALT. We currently set our own schedule of payment without any incursion of fees or fines on clients' accounts. We also, so I just want to include by saying, without help from the state and indefinite court closures, postponing trial for a year or more, community members could potentially spend over $4,000 in fees. We urge a favorable report. Thank you for your time.
Thank you, Ms. Freeman. Mr. Johnson, you're next.
How you doing? Can everybody hear me?
Yes, we can. Go ahead.
How you doing? My name is Trayvon Johnson. I was invited here by JOTF to speak in favor of the Senate Bill 23. During my bail review, for charges that had been dropped down, the judge offered me the option of home detention with the box or waiting in jail. As Baltimore jail is extremely unpleasant, unsanitized place to be at, especially during the coronavirus, I chose to go home. It was not explained properly to me how much going home would cost me though. ASAP Home Detention and the monitoring company charged me $240 up front and told me that I would have to pay a minimum of $70 every week or risk going back to jail. I didn't have the money. It made no sense to me that during a pandemic where people are hurting financially and mentally that they would charge people $240 just to stay home and stay safe. I explained to ASAP my concerns with the cost and was threatened by the staff to sign the paperwork or go back to jail. When I asked them to explain the documents to me before I gave my signature, they repeatedly refused. My freedom was at stake, and they were taking advantage of the moment to charge ridiculous high fees. The upfront cost and the following $240 per month even exists is a serious problem. There are no fees in Montgomery County, and I firmly believe that the entire state should follow suit, especially for those who don't have the money to buy their freedom. Senate Bill 23 will go a long way towards fixing the issue for myself and the hundreds of others struggling right now for these reasons. And I urge a favorable report, and I know that Senate Bill 23 will be a positive income on the city. Thank you.
Thank you, Mr. Johnson, for sharing your personal experience. Do I see any questions? I do not. Oh, Senator Carter, go ahead.
Thank you, Mr. Vice Chair. So I want to thank Senator Hellman for bringing the bill. It actually legislates one of the recommendations that we made this summer and fall with our courts and COVID's work group. And so I definitely have empathy for the bill. So I want to be clear. Is this correct statement? All this bill does is simply ensure that nobody that qualifies as indigent would have to pay for home detention, and that money would come out of the pretrial services grant fund. Is that correct?
I want to clarify. It does say that they cannot be charged. It does not mandate that the funding come from the pretrial fund. It provides that as an option.
And so qualifying as indigent should be fairly simple, because everyone that is arrested is qualified immediately for either court-appointed attorney or public defender. So it would seem to me that that would be no issue.
Correct. I agree.
Okay.
All right. Thank you, Senator Carter. Senator Casserly.
Thank you, Mr. Chairman. This is a question for the sponsor. I'm just, Senator Hellman, I'm looking at the bill on page 2 of the bill, looking at line 20 and 26. And I don't deal in this area of the law, so this is more of a technical question because I don't really know how this works. But on line 20, it says the defendant may not be required to pay a private home detention monitoring agency, private, underlining the word private, and then down on line 25, it says a home detention monitoring service or global positioning system is provided by the state. So how is it, private or state?
Good question. So it can be either, and it depends on the jurisdiction. I've dug into that a little bit in my own county, and I can tell you.
Says, but paragraph 3 says this, it applies to private, only to private, right? It says you may be able to pay a private, but then it jumps down to provided by the state. So is it private provided by?
So we're saying that you can't be charged if the county charges you, if the state charges you, as in Baltimore City, since the state runs the program in Baltimore, the pretrial program in Baltimore City, or a private entity. So you can't be charged by any of those groups.
Okay.
And you want me to explain the different, why they would be why they would be private in one place as opposed to public in another? I'm happy to do that.
Yeah, well, I guess my real question is, I understand that most of the witnesses have to do with indigency and I can't afford to pay for it. But as I read this, what it says now is, if I'm making 6 figures plus and I'm released because of a DUI, that if it's provided by the state or local jurisdiction, they can't charge any fee at all. And I'm sort of wondering why that would be.
No, that's not our intention. Our intention is only not to charge for people who are deemed indigent.
Okay, so
this, we can charge you.
Okay, so I'm just the way it's laid out here. Says defendant may not be required to pay for private. That's any defendant, private, any fee, and it says if, and then number 1 is they're indigent, or number 2 is as provided by state or local government. So number 2 is it applies to me even though I'm not indigent. I make $500,000. I don't, but if I make $500,000 a year and I'm released because of, I just think that this says this isn't consistent with what you're saying. That's my only point. We can talk with counsel for the committee, but
happy to do that.
I just think that we ought to be able to charge people who can pay for it so we can.
Totally agree with you. We should
Okay.
charge people who can pay. We're in
All right,
agreement.
that was my only question. Thank you.
Thank you, Senator Casserly. Thank you, Senator Hedelman, for bringing this great bill. Seeing no further questions, we'll move on to the next bill, which is Senate Bill 78. That is me. So let me grab my testimony here as I juggle the paperwork. Members of the committee, I'm going to begin a story and then take a brief legal interlude and then come back and tell you the rest of the story. I want to tell you the story of a young man named Elijah McClain. Does that name sound familiar to you? We all know the name of George Floyd, whose murder has kicked off months of hard work by this committee. And of course, we know Mr. Floyd's story. And to the extent that we hear Elijah McClain's name, it's always only as part of a list. George Floyd, Breonna Taylor, Ahmaud Arbery, Elijah McClain. But in many ways, the story of Elijah McClain is the most important. To me, it's the scariest, most dystopian, most troubling story. Elijah McClain was an oddball vegetarian who was homeschooled by his mother. She had moved them to Aurora, Colorado to ensure he didn't get into trouble. And he didn't. He had never been convicted, adjudicated, or even arrested for any crime. On August 24th of 2019, McClain, just 23, was walking down the street, minding his own business, likely listening to music. Someone called police on him saying he looked, quote, sketchy. The 911 dispatcher asked if he was armed, and the caller said he was not. The dispatcher asked if anyone was in danger, and the caller said no. Nonetheless, 3 police officers showed up and confronted Mr. McClain. Mr. McClain then did something he should not have. He resisted arrest. It was absolutely the wrong decision, but perhaps not a terribly surprising one, given that, well, he was doing absolutely nothing wrong. And so the officers subdued him using a carotid control hold. Now, this is all pretty terrible, but unfortunately not all that different from many of the stories we've heard this year. However, the story of Elijah McClain is about to take a dramatic turn for the dystopian, a turn I want to tell you about after a brief legal interlude. When you get pulled over for having a couple of drinks, the police can make you take a breathalyzer without a warrant, or you lose your driver's license. They can arrest you and take you to jail without a warrant. But the Supreme Court has held, as recently as 2013, in Missouri versus McNeely, that in almost every circumstance, they cannot draw blood without a warrant. Not a vial, not even a finger stick. It's just a finger stick. What's so sacrosanct? And of course, that's the point. What's so sacrosanct? Your body, your dignity, your ability to live in a society where law enforcement can't use the tools of medicine as an instrument of enforcement or control. The Supreme Court believes that. I think you believe that. And our democracy needs to believe that in order to function. In that carotid hold, Elijah McClain was struggling and in distress. He threw up twice. The police called EMS. EMS arrived to find him unconscious. Paramedics are lifesavers, quite literally, but let's remind ourselves, they are not medical doctors. When EMS arrived, the police started telling them big fish tales. Elijah McClain, all 5'6" of him, suddenly had superhuman strength. It had taken 3 officers just to subdue him. The paramedics got the hint. They stuck a needle in his arm and plunged in a drug called ketamine, enough ketamine to put down a 280-pound man. 3 days later, Elijah McClain was dead. What is ketamine? It's not a poison. It's not even new. It's anesthesia. It's used by highly trained anesthesiologists in hospitals and medical settings. Until recently, it's only been used in one non-medical setting, battlefields. This bill does two things. One, it bans the use of ketamine by law enforcement or at the direction of law enforcement. Two, after the death of Elijah McClain and worried about the dramatic increase in ketamine use, the Maryland Institute for Emergency Medical Services, MIMS, instituted new and strict limitations on ketamine use, including requiring medical doctor approval in most circumstances. This bill codifies that protocol. The story of Elijah McClain has ended, but if we don't act, the story of the next Elijah McClain here in Maryland, in your legislative district or mine, is just beginning. And with that, Mr. Chairman, I would note that my next witness was supposed to be Dr. Paul Applebaum. We had to shift schedules because of the snow yesterday, so Dr. Applebaum is no longer able to testify. But I wanted to tell you what he might have said. He's a doctor and professor at Columbia University and the nation's foremost expert on the issue of so-called excited delirium. Excited delirium is the undefined catch-all phrase that is being used more frequently to justify the administration of ketamine. I am not a doctor, but Dr. Paul Applebaum is. And he believes that excited delirium is likely not a thing. And it wouldn't be the first time that people used a catch-all phrase to define something and everyone accepted that when in fact there is no such thing. In 1707, doctors identified and published a case study on something called the vapors. And for 200 years, lots of folks were diagnosed with having the vapors. It was a catch-all phrase. It didn't mean anything. There's no such thing as the vapors. It's not a real thing. Dr. Applebaum would say the same thing about excited agitation. It's a garbage catch-all term that provides a framework when it's challenging to diagnose someone. It's not recognized by the American Medical Association. It's not recognized by the World Health Organization. It's not recognized by the American Psychiatric Association, whose DSM-5 is the authoritative diagnostic manual on these topics. What Dr. Applebaum would tell you is that EMS workers and police officers should diagnose the underlying condition that is recognized that is causing the delirium. It could be intoxication. It could be a psychotic episode. It could be that the person is just scared. And that would be Dr. Applebaum's testimony. I ask for a favorable report on this bill, Mr. Chairman. And I don't know if you've gotten settled, but I can either introduce the next witness or you should feel free to do so.
Well, thank you, Mr. Vice Chair. I'm finally settled back. Thank you for taking the saddle. So then next, we have your Mr. Webb is next for your panel. Mr. Webb, you're up next.
Hi, good afternoon, everyone. Thank you for having me. So my name is Dr. Michael Webb. I'm the medical director of anesthesia at the Anne Arundel Medical Center in Anne Arundel County. And, you know, I support everything that's been said so far. Are you able to hear me? Okay, just making sure. Yeah, so I support everything that's been said so far. Ketamine is a very potent anesthetic, and it's used in the operating room and emergency rooms and in the battlefield, as has been said. But it has severe side effects and really needs to be given by medical professionals, people who are able to evaluate the situation, the person who's going to receive the drug, and also be skilled in giving the drug. There's multiple ways that an inappropriate dose could be given. And I imagine in a heated situation that only increases. So we have dosing issues, you have side effect issues. Depending on the person who's receiving the drug, if they've received other drugs, you're not just talking about the effect of ketamine, you're talking about the effect of ketamine in combination with any other drugs that may be in the person's blood system. The person, and whenever ketamine is being given to anybody, somebody should be there who's skilled in airway management and ACLS in the event of a respiratory arrest or a cardiovascular arrest. So I'm open to any questions that anyone may have about this.
Thank you, Mr. Webb. Dr. Webb, next we will have Alan Butch.
Good afternoon. Can you hear me? Excellent. So Mr. Chairman and committee members, senators, my name is Alan Bush and I'm an Assistant Chief of the Montgomery County Fire and Rescue Service, presently assigned as the Section Chief for Emergency Medical Services. And I uploaded a longer statement that I hope you take a look at. I've been interested in this issue since 2013 when I worked with our police department to find ways to prevent the deaths of patients that were suffering from severe agitation and psychosis. We'd seen a couple of these that led to in-custody deaths, and that had a pretty profound effect on our community and our members. So this effort led to increased training and attention to foster early recognition of this syndrome by 911 call takers, police officers, and our paramedics, with the goal being early treatment to avoid cardiorespiratory collapse that you just heard about. Since 2013, the evidence-based medicine in the emergency medical community has evolved to indicate that ketamine is the best available medication to deal with this syndrome. Its use became permissible for Maryland paramedics in 2018. We in Montgomery County were not able to obtain it in sufficient quantities to deploy until the summer of 2020. In the intervening time, both I and our medical director had become aware of the appalling news articles that the senator described, reporting that at the behest of law enforcement officers, paramedics had given ketamine for non-medical purposes. I want to be absolutely clear. We find this to be abhorrent and absolutely unethical. And in our training program for ketamine, we made this clear to our workforce before we allowed them to use it. We also talked to them about the high likelihood, because of ingested chemicals before we arrived, that there might be other respiratory issues. And we told them to be very mindful of that. Since that time, we've reviewed every use of ketamine by our clinicians. And we are very proud that its use has resulted in several lives saved. So we understand the goals of this bill, but we believe that there are things that should be amended. First, there are law enforcement officers in the state who are also paramedics who use ketamine in the course of their medical duties, not their law enforcement duties, but their medical duties. The bill needs to include language to allow that. The bill also includes clinical language from our protocols. The paramedic protocols in Maryland are mutable and are developed and changed by a consensus-based process that is already defined in COMAR Title 30. So we recommend that this language be taken out. Should the General Assembly decide that this issue needs further study before making the decision, we would be very happy to participate in whatever process is devised. I have included some subjects for study in my written testimony. Thank you very much for your time and attention.
Excellent, thank you. Next, we will have Mr. Kaufman.
Good afternoon. I'm Ben Kaufman, and I'm a registered nurse and battalion chief in Montgomery County, assigned to provide operational oversight to our EMS section. And I thank you for the opportunity to speak today about something other than COVID-19. I'll focus on the clinical applications of ketamine and severe agitation. Ketamine has various indications depending on the dose. It affects the body in different ways at various levels, kind of like ibuprofen, which is used at lower doses for mild pain and headaches, and higher doses for anti-inflammatory effects and musculoskeletal pain. At lower doses, ketamine is used for pain control. And at moderate doses, we use ketamine to treat patients who wake up during CPR. Yes, this can happen. And for managing patients during intubation. And at the high dose range, we use ketamine to safely anesthetize patients who may be in danger of death as a result of severe agitation. This is a medical syndrome characterized by extreme erratic behavior, violence towards self or others, superhuman strength, and an inability of the body to regulate itself. These patients are on a spiraling, uncontrolled course towards sudden death. This is just as life-threatening as a heart attack or severe bleeding, and it requires the same level of immediate intervention. The treatment is a safe and effective dissociative dose of ketamine. The science behind these unfortunate outcomes is largely observational and retrospective because cardiac arrest virtually always occurs in the field. Randomized studies are simply impossible to conduct, but through post-mortem analysis, we see that some patients have a biochemical predisposition to dying as a result of severe agitation syndrome. And what makes this so challenging to talk about is that unlike a heart attack, severe agitation often occurs in public and draws the attention of police and bystanders. And it can be a particularly traumatic experience for onlookers until paramedics arrive with ketamine to stabilize the situation and the patient. So I support the intended purpose of this bill to prevent police overreach and abuse of power given the close working relationship between police and EMS agencies. Ketamine should never be indicated for non-medical cases. As drafted, however, the bill presents two logistical challenges that I would urge the committee to address. First, under Article 3-523, provide an exemption for law enforcement officers who are also trained as paramedics, allowing the administration of ketamine as indicated by medical protocol. And second, under Article 7-404, reconsider this language that legislates medical care by removing the section that codifies current protocol. And I thank you for allowing me to share with the committee my experiences from the field.
Excellent. Thank you very much. And thank you for your service. So next, that concludes the testimony for the proponents. We'll move on to the opposition panel, which is Mr. Delbridge. Mr. Delbridge, are you here?
Hi there. Good afternoon. I'm Dr. Ted Delbridge. I'm the Executive Director of the Maryland Institute for Emergency Medical Services Systems, or affectionately known as MEMS. And MEMS is the state agency responsible for oversight and coordination of the statewide emergency medical services system. We do that in a number of ways, but among them are licensure and certification of EMS clinicians, the emergency medical technicians and paramedics, and promulgation of the clinical protocols used by statewide EMS clinicians in the field. Nearly 20 years ago, the legislature created and vested the State Emergency Medical Services Board with responsibility for protecting the public's interest with regard to emergency medical services in Maryland. The board includes practicing physicians, nurses, EMS clinicians, and public members. And one of the ways it exercises its statutory responsibilities is by reviewing and approving EMS protocols annually. These protocols guide and authorize EMS clinicians' care in the field statewide and are developed and vetted in an elaborate process that involves multidisciplinary input and includes the EMS medical directors, practicing physicians for all 26 EMS jurisdictions. Ketamine has been used in EMS clinical protocols since July 2018. It has valuable and important properties that include analgesia and sedation, and includes less depression of airway reflexes and adverse hemodynamic effects than other available agents do. It has indications for analgesia or pain control, as you've heard. It's an alternative to opioids like fentanyl and morphine. It's important for sedation, especially when trying to facilitate adequate respiratory support. And sometimes it's indicated for severe agitation. And sometimes that agitation is the result of, as you've heard, life-threatening abnormalities or intoxications that cannot even be assessed until there is better attenuation of the agitation that started. The national spotlight that inspires Senate Bill 78 is, in my opinion, out of focus. It's not about ketamine, an important and useful medication when used appropriately. It's about EMS clinical protocols. It's following the protocols as directed, and having appropriate patient monitoring is necessitated by whatever therapy is provided, whether ketamine or something else. And that is what goes to the crux of the anecdote the senator conveyed. EMS clinicians in Maryland follow protocols. Compliance is a matter of ongoing monitoring facilitated by a common statewide EMS electronic medical record. Deviations result in remediation up to and including suspension or revocation of credentials. And EMS clinicians do not accept therapeutic directions from law enforcement officers. They follow protocols. They seek direction from appropriate physicians.
Time.
Protocols indicate. and these points continue to be emphasized and reiterated. And we ask for an unfavorable report for Senate Bill 78.
Excellent. Thank you, Mr. Delbridge. And with that, that concludes the testimony for this bill. We'll now open it to the committee members for questions. Senator Castley, you're up.
Thank you, Mr. Chairman. Dr. Delbridge, quick question for you, sir. This is ketamine, and apparently if it's misused, it can be fatal, right?
Correct.
I imagine that your paramedic folks that are operating throughout Maryland probably have in their medical bag quite a few different medicines, and that if inappropriately used could be fatal or seriously injurious to the patient's health. Would that be safe to say?
That's exactly safe to say. And the protocol review process, the process that creates protocols and subsequently reviews them, takes all these things into account. And the utmost important is the safety of the public that the EMS system encounters.
Okay, so if I'm one of your paramedics and I misuse any one of those items, and it's brought to your attention, what happens? What happens to me? What's the process in place?
Well, it depends on the nature of the deviation. Many of these things occur.
I gave ketamine because a cop told me to, and I got there at the last minute. I didn't see a darn thing, but the cop is my friend, and I gave him ketamine.
That would be escalated to what's called the provider review panel, a panel of peers, and ultimately come to the EMS board for adjudication. And those cases.
And what could happen to me?
You could lose your license to practice EMS in the state.
Lose my license. Okay.
And what Senate Bill 78 does, although well-intentioned, it usurps or circumvents the responsibility and authority of the EMS board. It's redundant to the work that's already ongoing, and it codifies in statute a very specific and narrow part of EMS clinical protocol, which suggests that there is additional expertise beyond the current protocol development participants in process. And it embarks on a slippery slope as there are more than 55 EMS protocols that are multidimensional, involving more than 24 different medications.
Well, I would imagine that if we pass this, we'll be back for a whole lot more. But if I could ask Dr. Webb a few questions, please.
Dr. Webb, there you go.
Yes.
Dr. Webb, thank you for coming in today, and I appreciate your testimony on the dangers of the misuse of ketamine. I imagine that in your practice, you and the nurses and PAs and folks under you probably administer quite a few medicines that, if misapplied, could result in death or serious bodily injury to your patients. Is that fair to say?
Very fair.
And the current processes in place to correct such a misuse, I expect that would be both the licensing authorities as well as the tort laws. Is that correct?
Yeah, but if I could also add, it's not just misuse. It's when you're applying these medications, the expected result doesn't always happen. Sometimes you get less of an effect than expected, but sometimes you get more of an effect. And it also depends on how you're giving it and whether it's not, I don't want to say given inappropriately physically, but there's a difference between giving a medicine in a muscle or accidentally getting in a vein and giving that same dose.
Sure, and I would hope that you and Dr. Delbridge, being the two medical folks on this panel right now, would pick up the phone from time to time and advise each other as to, hey, I'm not sure your protocols are strict enough, or maybe you should get some additional training. Wouldn't that be an appropriate way to correct sort of potential misapplications of these drugs?
That would take care of some of the problems that may be encountered, but
well, do you disagree with the folks who have testified here today that say that, hey, EMS people using ketamine is an important tool, and we don't want to take that tool away from EMS people using ketamine in the proper circumstance, with the appropriate training?
I think in my role in this testimony, I'm more here to speak about the drug itself and the stand of both the American Society of Anesthesiologists in a collaborative document that came out with the National ER Organization, which said that ketamine should be used by medical professionals for medical reasons, basically.
No, and I think that's what Dr. Delbridge is saying. I mean, nobody in this panel is saying, let's give this just to anesthetize uncooperative people being arrested just because that's not because of a medical condition that's appropriately to treat with ketamine. The issue is, should we as legislators continue with the current protocols that delegates to you all the determination of when it should be given, what it should be given for, who should get it, what the dose should be, how it should be administered. Should we leave that with you, which is where we currently have virtually every medicine, or should we take this one out of the every medicine category and start developing a special category that we cut out the current systems that all of you have developed as professionals to deal with these issues and create a new ketamine protocol and that takes it away from the normal protocol that controls every other drug that those guys carry in those ambulances. I mean, that's really the issue before us. Should we treat ketamine differently than everything else? Or can we trust the medical professionals to work together to tell the EMSs, here's how you give it, here's the dose, here's the circumstances. If you deviate, you might get sued for malpractice, you'll probably get fired or demoted, lose your license. Can we trust that to continue, or should we develop a whole new protocol that goes through the legal system rather than through the current protocols that were just described by Dr. Delbridge and Mr. Kaufman and these other folks from the emergency medical services?
Well, having worked with the emergency medical services through the city of Annapolis, I'm very comfortable with both their protocols and their access for immediate medical direction.
No, I think Dr. Delbridge would probably say the same thing, and they all know each other. But thank you very much. I appreciate Dr. And I thank you for coming in. I appreciate where you're coming in. This is serious stuff. This is serious medication that does not belong in the hands of the local police officers or under their control or under their discretion. And I think Dr. Delbridge is I feel confident he's saying exactly the same thing, as well as are these other providers, these other emergency medical people. It seems like all of you folks are on exactly the same protocol. And it's just, we're reacting to a situation out of Colorado where I'm not sure how in Colorado anybody looks abnormally sketchy, because that's Colorado. That's goes with the turf. And then we got people making an illegal arrest with an illegal chokehold, giving illegal directions that are illegally followed with an illegal chokehold, and somebody dies. I'm like, okay, yeah, all right. Anyway, thank you, Mr. Chairman.
All right, thank you, Senator Castley. Notwithstanding your comments on Colorado citizens and residents, we're all in agreement. All right, Senator Sidnor, you're up.
Thank you. This question is, I was listening earlier to, I think, Mr. Alan Bush. I don't know if I'm mispronouncing your name, I apologize. But you were talking about administration and of this drug, and I wanted to make certain that I was hearing you correctly. Did you say that there have been times when this medicine had been administered by people who should not have been administering it? Did I understand that correctly?
So what I was referring to over the summer, and certainly Mr. McLean's case was one of those, but there was a series of articles that came out about paramedics in Minneapolis. So I want to make it clear that I'm not talking about anywhere in Maryland, and certainly not in Montgomery County. Okay. But yes, there had been cases where paramedics had given ketamine at the direction of law enforcement officers for law enforcement purposes, or had participated in threatening detainees with the administration of ketamine. And it's appalling. I absolutely agree, it's appalling. That's why we were very careful to instruct our personnel, that's not going to happen. And that's why we review every case to ensure that it's an appropriate administration. But this is, I'm sorry, go ahead.
So if that type of incident happened here in Maryland, I'm assuming the the Maryland Institute for Emergency Medical Services Systems, they have the ability to get, or I guess another health licensing boards, they have the ability to withdraw a license from an EMS personnel who didn't abide by the proper protocols. But I'm curious, is there any responsibility, or what befalls that officer who asks for that medication to be used in that manner?
Yeah, it's an interesting question. So speaking for the EMS side, so we operate a quality assurance program in our own county. We are required to do that by MIMS, who's our regulatory agency. So if we had a paramedic who did that, we would most likely immediately suspend their privileges to practice. And we would then have to turn around and report that to MIMS so they could look at the case and how we're handling it, and then decide how to proceed further. And it would more than likely, you know, what Dr. Delbridge talked about earlier, that would more than likely happen. From the police officer perspective, I can say with a lot of confidence that their leadership shares the same feelings that we do. We've been at this since 2013. Back then, it was not ketamine that we were talking about, but Haldol, which is another anti-agitation medication. But the same thing back then. Nobody from the police side or fire rescue side wanted to see medications misused for non-medical purposes. So I imagine that their actions against their personnel would be likely the same as ours.
Gotcha. Yeah, because I can remember when this incident happened, I reached out to my local, a local police officer and asked whether or not this happened or was authorized within his department, and the answer was no. But it certainly gave me pause. It made me wonder what law enforcement could inject in my body, because I was not responding in the way that they wanted me to respond. So it's good to hear that no one should be giving out medication to anyone for non-medical reasons. So I appreciate learning about that in this hearing, and thanks for answering my questions.
My pleasure. Thank you.
Excellent. Thank you, Senator Sidnor. All right, looking around the committee, seeing no further questions, that will conclude the hearing and the testimony, or the testing and the hearing for Senate Bill 78, Senator Wallstreicher. We'll next move to Vice Chair Wallstreicher with Senate Bill 229. Vice Chair, you're up.
Thank you, Mr. Chairman. I'm so glad we had that conversation that we just had. It was an important one. I appreciate it. So, Mr. Chairman, colleagues, you heard from Senator Heddleman, who did a great job explaining how we eliminated much of the cash bail industry some years ago here in Maryland, and that's a good thing. That means folks aren't kept in jail due to poverty. It also meant that more defendants are being returned to our community under GPS supervision. Decriminalizing poverty and community-based supervision are unambiguous good things. Unfortunately, we have unintentionally created a new problem. You heard a little bit about this earlier. Most defendants, including indigent defendants, are required to pay for their own ankle bracelets. Charging folks for their own pretrial services, including GPS, is simply money bail by another name. It punishes poor people, and it disproportionately impacts people of color. We need to fix it. Over the past few years, with the incredible advocacy of the Job Opportunities Task Force and many other civil rights organizations, we have worked to eliminate GPS monitoring fees, but we've struggled to crack a nut. Who pays for it? The counties? That's an unfunded mandate, and MACO will kill the bill. The manufacturers? Well, they'll just pull out, sending these folks back to jail. And Senator Carter and Senator Casserly, you hit on this very problem earlier in the discussion. So lo and behold, as we've been wrestling with this issue, the House has separately struggled with the same. And Delegate Moon came up with a surprisingly elegant bipartisan solution. It passed the Judiciary Committee unanimously and the full House unanimously last session. Turns out what we used to call GoCap has a pretrial services grant. And so in one sentence, this bill does two things. It extends out the grant for a decade. And two, it eliminates all pretrial fees, including GPS monitoring fees, for any defendant in a jurisdiction that accepts pretrial services, a pretrial services grant. It took us years, Mr. Chairman, to find a solution, but I think we have found it. We're here now with something effective and graceful. And I want to thank my friends at JOTF, especially for their incredible leadership and important voice in leading the charge on this issue. I ask for a favorable report.
Excellent. Thank you, Vice Chair Wallstreicher, for your for bringing this forward to us and for your advocacy over the years. So we will move to your primary witness, who will have 5 minutes, and that is Ms. Bala. You are up next. How are you?
I'm doing well. Thank you for having me. As you said, my name is Nila Bala. I am the Associate Director of Criminal Justice Policy and Civil Liberties for the R Street Institute, which is a nonprofit center-right public policy research organization. And I also speak to you as a former public defender from Baltimore City. And I am speaking in support of this bill of SB 229, which, as you've heard, would prohibit charging a fee to defendants as they're participating in certain grant-funded pretrial programs, and would also extend the termination date of the grant funding. We are in favor of this bill because we know that many individuals pretrial can be well supported in the community without being incarcerated. And pretrial incarceration should be reserved for those who truly pose a danger to their community and not simply because of an individual's poverty. This is because incarceration is extremely disruptive. It can mean the loss of a person's family, their job, their home, and even a few days behind bars can lead to these outcomes. Deprivation of liberty pending trial is a harsh measure by the state, and we must be circumspect in its use. There is a legal presumption in Maryland, as in most states, that defendants should be released on the least restrictive conditions necessary to ensure community safety and their court appearance. And pretrial services can be the bridge when there is a finding that an individual can remain in the community safely, but needs some assistance during that time. We see this bill as one that would equalize justice and ensure that income is not a barrier to participating in pretrial services. The bill would also equalize justice across counties because many counties in Maryland already do not charge fees for pretrial services. We see that pretrial services are vital. They can help an individual be successful in their community. These programs can provide, as mentioned, GPS monitoring, drug and alcohol treatment, and other needed services while an individual is awaiting trial. Another function of pretrial services is to help an individual remember to appear in court, for example, through cell phone reminders of hearing dates. These reminders can help individuals make it to court and avoid a failure to appear finding by the judge, which can often lead to a warrant being issued for the defendant's arrest. I saw this many times during my tenure as an assistant public defender in Baltimore. When these warrants are executed, an individual must be booked, charged, and incarcerated, and the state and individual pay a heavy price. But pretrial services can help make sure that the individual comes to court and avoid these results. So pretrial services are not only good policy, they make fiscal sense. And as a conservative organization, R Street does support ending the practice of charging defendants fees for pretrial services. We're also in favor of a number of other bills that are being heard by this committee, including SB 23, which would exempt indigent individuals from the home detention monitoring fee, and SB 201, which I believe you'll be hearing tomorrow, that would decrease the waiting times for certain expungements. These bills would similarly equalize opportunities to access services in the justice system. I appreciate this opportunity to testify. I'm available for questions, and I ask for a favorable report on this bill.
Thank you, Ms. Bala. Next, we'll have Ms. Rothstein. You're up.
Good afternoon, Chairman Smith, Vice Chair Waldstreicher, and members of the committee. My name is Melissa Rothstein. I'm the Director of Policy and Development at the Office of the Public Defender. Thank you for this opportunity to testify in favor of Senate Bill 229 with amendments. SB 229 will extend the Pretrial Services Program grant fund and prohibit counties from charging defendants for their participation, both of which are important to provide for greater statewide consistency, a wider range of tools available to facilitate pretrial release, and a fundamental fairness that does not rely on finances to determine liberty. Most defendants can be released without any pretrial services and will pose no safety or flight risk. National data shows that defendants generally return to court, and Maryland's failure to appear rates are consistently below the national average. However, to the extent that pretrial monitoring is needed, every county should have the basic tools available, and this fund can provide jurisdictions without an existing pretrial system the same basic options as their neighboring counties. You heard testimony earlier on SB 23 about the problems with charging for home monitoring. This bill can help realize the important goals shared with SB 29 by providing funds to cover the costs for monitoring bracelets and other release tools. While OPD supports the overall intent and goals of the fund, the legislation should be amended in two key respects. First, this bill should not require the use of a validated risk assessment tool as a condition of receiving grant funds. While once considered a preferred practice, these tools have become increasingly controversial due to their inherent racial biases. Racial disparities are widespread at every step of the criminal justice system, and the algorithms underlying risk assessment tools continue and often exacerbate these disparities. The Pretrial Justice Institute, which was previously among the strongest advocates of risk assessment tools, has since changed its position in recognition of the structural racism and institutional inequalities that underlie these instruments. Insisting upon the use of these tools is counter to the bill's underlying goal of promoting equitable practices. Second, this bill should require that awarded funds increase pretrial release rather than result in unnecessary widespread monitoring. Funding should also allow for DPSCS to expand and improve its home monitoring equipment and process for Baltimore City pretrial services so that the large number of indigent defendants in the city are not subject to private home detention fees. Once again, thank you for your consideration, and I hope you will issue a favorable report with these key amendments to Senate Bill 229.
Excellent. Thank you, Ms. Rothstein. So that concludes the testimony for the proponents. We'll now switch over to the opponents. And first up is Ms. York. Ms. York, the floor is yours.
Thank you so much. Greetings, Mr. Chairman and members of the committee. I'm Karen York, Chief Executive Officer of the Job Opportunities Task Force. So I'm signed up to testify in opposition to Senate Bill 229 as drafted, and speaking mostly to the points that Melissa just raised in her testimony, but it really may come across as favorable with amendments. But my remarks are going to speak to being opposed to the legislation as currently drafted, and looking forward to working with the sponsors to ensure that the legislation is aligned with what we also hope to pass Senate Bill 23, as both are compatible and very much needed to really address the issue of the criminalization of poverty in Maryland. So my opposition focuses on three core points. And again, this is reiterating a lot of what Melissa just indicated. Yes, in 2018, the Pretrial Services Program Grant Fund was established. This was great and very much supported by all of the advocates who recognize that the full impact of the rule could not be realized if the state did not adequately invest in pretrial services, especially for those counties lacking a pretrial services function. However, funding for the counties was tied to use of a risk assessment tool, specifically a validated, evidence-based, and race-neutral risk scoring instrument. We understand that this is the language. However, my second point, risk assessment tools are so contentious that the coalition that advanced pretrial reforms in 2017 failed to reach consensus. This includes the nation's leading pretrial reform expert, the Pretrial Justice Institute, which is based in Montgomery County, and various other pretrial reform advocates that include Public Justice Center, Out for Justice, Baltimore Action Legal Team, ACLU, you'll hear from Leaders of a Beautiful Struggle, and the Open Society Policy Center, to name a few, that have denounced the use of risk assessment tools due to the overwhelming evidence of racial disparities. Moreover, the term race neutral is inherently oxymoronic as risk assessments are inherently racialized. Even if a practice is on its face race neutral, it can still have an overwhelmingly discriminatory impact on certain races. In fact, during the 50s and 60s, racially neutral policies and practices were the fundamental building blocks of the racialization of the criminal justice system. And we're seeing this today as many of our policies are framed race neutral, but are likely to produce a pronounced negative impact on racial communities. Lastly, Senate Bill 229 does not provide pretrial funds to the city of Baltimore. The law prohibits DPSCS from funding eligibility because they're a state agency, but DPSCS runs pretrial services in Baltimore City, where most of the most financially vulnerable and indigent populations of the state of Maryland reside. For these reasons, we oppose Senate Bill 229 as drafted and look forward to working with the sponsors. Thank you.
Excellent. Thank you, Ms. York. And next we'll move on to Mr. Love. Mr. Love, you're up.
All right. Good afternoon, Chair, Vice Chair, Committee. Davon Love, Leaders of a Beautiful Struggle. Testifying in opposition, really just to talk about the race neutral risk assessment piece of it. We actually agree with the spirit of the bill, just in terms of what it hopes to accomplish. But just wanted to make sure that we underscore the importance of the downfall or drawbacks of race neutral risk assessment tools, as they conceal the way in which societal notions of Black deviance and pathology operate in the collective consciousness of American society, which actually trickles down into many of the service providers that will be connected to administering risk assessments. And there's been numerous research that's been done on some of the drawbacks of risk assessment. For instance, race neutrality as a standard, and that language is important because it would obscure the notions that are embedded about things like previous criminal history. A race conscious approach would question the way in which one's criminal history actually equates to one's being prone to criminality. So without a consciousness of the way in which the criminal justice system has impacted people of African descent, people of color differently, risk assessment tools that are race neutral would miss that. And in fact, there's a ProPublica article that actually details from May of 2016, that actually details the way in which folks who were scored similarly on risk assessment tools where the person who was Black was assessed as a flight risk and a risk to public safety, and the white person was not. And so again, generally not opposed to the spirit of the bill, but the risk assessment, race neutral risk assessment tools is something that as a practice in creating alternatives to pretrial detention is something that if it's not addressed directly, then it can lead to perpetuating some of the kinds of racial disparities that those who are criminal justice reformers are hoping to undo. So with that, we urge opposition to this bill.
Excellent. Thank you, Mr. Love. Okay, with that concludes the testimony for Senate Bill 229. We'll now open it up to the committee for questions. Seeing no questions, that will conclude the hearing for Senate Bill 229. Thank you, Vice Chair Wallstreicher. Next, we have Senate Bill 263. Vice Chair Wallstreicher. Mr. Wallstreicher, you're up.
Thank you, Mr. Chairman. I think I have completed my bills for today.
Okay, got it. All right, excellent. My apologies for that. All right, then we'll
Mr. Chairman, I think I'm the prime sponsor on 263, and Senator Wallstreicher is my co-sponsor.
Excellent. Senator West, you're up. My mistake.
Thank you. I'm pleased to introduce Senate Bill 263, which has been brought to me by the Maryland State Bar Association's section on business law. This section represents all of the state's lawyers who practice business law. I served on the executive council of this section for many years, and I can tell you that any work product of this organization represents the consensus view of the state's business law attorneys. I'm going to start by thanking my co-sponsor, Senator Wallstreicher, for working on this bill with me. It's always great to partner with Senator Wallstreicher on important legislation. As you can tell from the title of the bill, it's a miscellaneous bill drafted to tweak the state's corporation laws in several respects in order to solve various problems with existing statutory language. The three principal changes made by this bill are as follows. First, many states permit companies organized in those states to include forum selection provisions in their charter or bylaws, specifying the court or courts
in which litigation about corporate governance issues must be filed. Such provisions can prevent simultaneous lawsuits in different courts, perhaps in different states. In the case of Maryland, such provisions can also ensure that Maryland courts familiar with Maryland law will be handling the lawsuits. Senate Bill 263 will provide that any such forum selection provisions must include one or more courts in Maryland. The bill also resolves the dispute between various Maryland circuit courts by making it clear that the forum selection provision may specify a particular Maryland court as opposed to enabling a plaintiff to select any Maryland court, no matter how far away from where the litigants and their counsel are located. Thus, the bill will enable the forum selection provision to require that corporate governance suits be filed in the Circuit Court for Baltimore City or Montgomery County or Anne Arundel County or another county in central Maryland, and thus eliminate the possibility that the plaintiff might choose to file the case in the Circuit Court for Somerset County or Garrett County. Second, on occasion, a corporation or real estate investment trust classifies or reclassifies stock, or increases or decreases the permitted aggregate number of shares of stock, and then proceeds forward with the classification, reclassification, increase or decrease prior to filing articles supplementary or articles of amendment with the State Department of Assessments and Taxation. In such rare situations, there is an argument that the shares of stock so affected are voidable. The same situation exists with respect to declarations of trust for real estate investment trusts. Occasionally, new shares of the REIT are issued before an amendment to the declaration of trust is filed with SDAT. This bill provides that any such prematurely issued shares cease to be voidable at the time the appropriate articles or amendment is filed with SDAT. Thirdly, the bill makes minor changes to the Maryland Control Share Acquisition Act to clarify the law and eliminate an apparent ambiguity that then U.S. District Court Judge Andre Davis found in the 2007 reported decision of Neuberger Berman Real Estate Income Fund, Inc. versus Lola Brown Trust Number 1B. The revisions contained in this bill are consistent with the outcome reached by Judge Davis and eliminate the apparent ambiguity. My bill also contains several technical amendments to Maryland corporation law, which my witness can go into at the request of the members of the committee. And with me today, I hope, on screen, is Bill Carlson. I've worked with Phil for many years. For a number of times, he served as the president of the business law section, or the chairman of the business law section. For even a longer period of time, he's been on the legislative committee. He's been before this committee on various occasions in the past. He's probably the state's foremost expert on corporation law at this time. And I'm pleased to give you Bill Carlson to be my principal and only witness.
Excellent. Thank you, Senator West. And with the exception of Vice Chair Wallstreicher, I assure you, you're probably the only senator, or the only two senators that understand what this bill does at this moment in time. But I trust you, we will do our homework before our voting session. Mr. Carlson, the floor is yours if you'd like it.
Thank you very much. Chair Smith, members of the Judicial Proceedings Committee, good afternoon. As Chris mentioned, Bill Carlson, Chair of the Committee on Corporation Law, the Maryland State Bar Association. This is my 6th year here talking about various corporate matters. I'm pleased to support Senate Bill 263, this year's miscellaneous bill, proposing improvements to our Maryland General Corporation Law and the Maryland REIT Act. I want to thank Senator West and Senator Waldstreicher for sponsoring the bill. Senator West ably went through 3 primary items. I won't repeat that, but I do want to mention a 4th item, which I think in these COVID-19 restricted times are important. We have some changes to 2502.1 and 2503 to facilitate stockholder meetings by virtual meetings, by conference calls and Zoom meetings. Our law, which was written at times, when we all weren't trying to be virtual, such as this Zoom hearing, doesn't fit quite well for what people are doing. More and more stockholder meetings are being held virtually. And it's actually greatly increased stockholder participation. Instead of people getting in their car and driving across the state or flying across the country to go sit in some hotel room for an hour, people can simply sign up on the Zoom call, and it's greatly increased the number of stockholders who are participating in stockholder democracy, if you will. There are three changes. One, the law right now says that if you have a remote communication or virtual meeting, everybody has to be able to speak and hear each other at the same time. I'm looking on my Zoom screen here and I see all the little red microphone mute buttons around. And you can imagine if you have 100 people on a call, all talking and speaking and listening to each other at the same time, it doesn't really work. So we want to strike the requirement that people have to actually all speak at the same time and hear each other at the same time. We all have our little, raised hand features. We also want to change the requirement. It was actually, I think, written as something good, but it's kind of now wondered whether it's a limitation. You can either have an in-person meeting or solely a meeting by remote communication. More and more people want to have an in-person meeting, but provide the option for people to participate virtually if they wish to. You can do both. We want to make it clear that that's okay. And the third thing is, if anybody has a virtual meeting and any stockholder objects, you have to provide a place for that stockholder who objects for the meeting. We want to be able to take that out. If you have hundreds of people in a stockholder meeting and there's a Zoom call and it's provided to everybody, it doesn't need to be a place. I've provided written testimony and I'm pleased to answer any questions, and I would hope for a favorable report of Senate Bill 263.
Excellent. Thank you, Mr. Carlson. Looking around the Zoom room, seeing no questions from the committee. Thank you, Senator West and Vice Chair Wallstreicher. That concludes the hearing for Senate Bill 263. Thank you, Mr. Carlson.
Thank you.
Seems that as though we are on the cusp of breaking a land speed record for JPR hearings, I will keep up and be very quick with the last two bills before us today. So with that, I'll start off with Senate Bill 599. This is a bill that was part of our hearings during the summer, so you should all be familiar with it. So I'll go over it very briefly and then take questions at the end. So Senate Bill 599 essentially prohibits law enforcement agencies from receiving the following military equipment from the 1033 surplus program. That's armored or weaponized aircraft, drones or vehicles, destructive devices, firearm silencers, and grenade launchers. That's it. So in our discussions over the summer, you may become more familiar with the 1122 program, which allows local law enforcement officer agencies to purchase the same military equipment for the same price that the military would purchase that, or that the federal government would purchase that equipment for. The 1033 program allows for the acquisition of that that equipment for basically the price of shipping, and therefore providing a greater incentive to go out and acquire those military grade tools. And so just very quickly, close to 12,000 law enforcement agencies have participated in the 1033 program since its inception. That means about $7.4 billion worth of military grade equipment is out there in our local law enforcement agencies. And that's as of June of 2020. From May 25th, which is the day of George Floyd's murder, to June 20th, there have been 29 instances of police using military-style vehicles at protests, 17 of which were obtained by the local law enforcement officer agencies through that 1033 program. So that's what the bill does. I will just direct the committee's attention toward the fiscal note. It's very comprehensive. It has some of the definitions that we discussed during the hearing. So if you're wondering what the definition of a silencer or a destructive device, it kind of goes in a little bit of detail there. But in particular, page 3 of the fiscal note I thought was pretty instructive. It talks about just the fact that, but for this program, but for the easy accessibility to these items, these law enforcement agencies wouldn't acquire them, and they're not needed during the normal course of conducting their duties. So any expenditure increase is likely minimal in any given year. First, equipment available through a federal surplus program is not always consistent with the needs of law enforcement agencies. Second, It's unclear if law enforcement agencies would otherwise independently purchase that equipment if it were not available through the surplus program. And it goes on. So with that, I'll just close with the fact that grenade launchers, MRAPs, armed drones, and other aircrafts that are armed, destructive devices, and grenade launchers are not necessary for our local, our state or local law enforcement agencies to accomplish their mission and their goals safely, and have no purpose and or reason being in our streets, in our communities. So with that, I will say that I will make sure that the committee has Maryland specific information for our participation in the 1033 program. I've got a pretty good Excel sheet that shows that since its inception, Maryland's participation in the program, we've acquired close to a little bit more than $11 million of military grade equipment through that 1033 program. And the fiscal note has a great breakdown of the counties and the jurisdictions and the municipalities that would be impacted by the prohibition of the equipment that is enumerated in the bill. So with that, I'll rest and take questions. I don't have any witnesses. We'll have a very, I'm sure, thorough discussion of this bill during a voting session as we commence with our police reform conversations. But look for this to be tacked on for the tail end of our police reform as we have LEOVR, use of force, and MPIA, which are much more significant aspects of police reform to address first. So with that, I'll take questions from the committee, and if there are no questions, I'll move on to the next bill, but I'll sit tight for questions at this moment. Okay, excellent. So with that, that'll conclude the testimony and the hearing for Senate Bill 599. I'll now move on to Senate Bill 601, which another bill that we heard over the summer, which is required drug or alcohol testing in a couple of situations. One is if an officer engages in conduct that results in the death of another, or a serious bodily injury of another, or if they discharge a firearm that is not associated with a training exercise. And then the bill is a little bit, it goes into the procedures as to how the law enforcement agency would go about compelling that test and where those test results would reside, and if and how they may be used after they've been collected. With that, if there are no questions, that will conclude the hearing for Senate Bill 601, and therefore the hearings for the day. And it is 4:44 before 5 o'clock. This is good work. So thank you all. I'm sure we'll see you tomorrow and Friday. We've got a long day on Friday. So let's enjoy this time now, and I'll see you tomorrow. Have a good one.